Good morning, everybody. We're going to call to order this Thursday, September the 19th, 2013 meeting of the Tennessee Alarm Systems Contractors Board. We want to welcome all the guests that we have here today to our meeting. And Ms. Bess, will you please call the roll?
Harvey,
Here.
Vivian Hickson,
Here.
Karen Jones, Mackenzie Roberts,
Here.
Stephen Tucker.
Here.
Let the record show that Karen Jones is absent, but you do have a quorum, Madam Chair.
Okay, thank you. The next item on our agenda is the agenda. Can we have a motion to adopt this agenda as presented if the members have had an opportunity to review it?
So move.
Okay.
I second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to adopt the agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. The next item on our agenda is the minutes from the July the 18th, 2013 board meeting. And Beth, do we need a copy of those to review, or are they on the iPad?
They're not on the iPad because I sent it to you by email, and there were so many.
Okay.
Did anybody review? I know Ken did because he sent me some corrections, and I made those corrections.
Okay.
The only other thing is I have to change the signature page, but
Right.
it won't affect the document.
Okay. All right. We have a motion to approve after review of these minutes.
So move.
We have a motion. Do we have a second?
Second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to approve these minutes. All in favor, voice by saying aye.
Aye.
All opposed? Motion.
Yes, all four sets.
You want these all just do
No, that's fine.
Yeah.
As long as I have a motion to adopt them and you've reviewed them, we're good.
board good with all four in one motion?
Yep.
Good deal. Mr. Kilgore, it's your moment for the legal report.
Before I do that, I'd like to introduce Sam Payne.
Thank you. I'm Sam Payne. I started day after Labor Day, I guess. I've come into the position that Wayne Pugh previously occupied, so I'm deputy counsel for
What
the reg
happened to Wayne,
boards.
if I may ask?
He's with the Board of Regents now.
Oh,
pretty
okay.
sure. So
Good.
he made a good move there, hopefully. I've been practicing for 21 years, mostly private practice. Last year, though, I was at the AG's office, so I'm keeping it within the state team and looking forward to working with you guys. Pretty much observing right now. I have a lot to learn, but hopefully you'll see me just the right amount, not too much and not too little. But thank you.
Congratulations and welcome.
Thank you, Madam Chair.
Okay.
I'll go ahead and get started with the legal report. Case number 2013-013751. Complaint was opened when company renewal was submitted to the board office, and it was discovered that either termination and/or transfer notices had not been timely received, or employee names were left off of the renewal for 4 employees. Respondent states that clerical oversight led to 1 employee name being left off, while termination notices for 2 employees were never sent due to oversight. The final name was left off because employee had changed position within the company and no longer works in an alarm-related or registered capacity. Respondent states that company has been going through a lot of growth and changes. No previous complaints were found against this respondent, who has been licensed since 2009. My recommendation is authorize formal and send consent order in the amount of $100 for failing to timely submit the 2 employee termination forms in violation of Rule 90-01-.069K.
Okay.
Make a motion to consult with counsel.
Okay, we have a
Second.
motion by Mr. Tucker, second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-005891. Complaint was established when the properly licensed alarm contractor filed a complaint with the board office. Complaint alleges that respondent had monitored approximately 50 of his accounts on a, quote, trial basis, but when owner of the complainant alarm company had complaints from some of his customers about monitoring service provided by respondent, he discovered that respondent was not properly licensed in Tennessee. He took all of his accounts back. A copy of an email between respondent and complainant shows that respondent was monitoring accounts for Tennessee customers, and a sworn affidavit filed by former customer states that respondent was monitoring her system she had purchased through complainant alarm company. No response was received to the complaint in writing. Under our policy guidelines, in this situation, I recommend authorize formal and send a consent order with a civil penalty in the amount of $25,000, which is 50 accounts times 500 for violating TCA 6232-304J, which is engaging in monitoring without licensure.
Motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with council's recommendation. All in favor voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-01-2091. Complaint was established when it was discovered that Respondent Alarm Company had failed to properly register one of its employees. Employee in question had worked for Respondent as a QA for some time and allowed his QA license to expire on or about November 30th, 2010. The employee and company stated that they believed his QA license reverted back to a registered employee license upon expiration. Regardless of Respondent's belief, they never submitted renewal information or reapplication for employee in question until May 14th, 2013. Employee worked without benefit of proper registration for approximately 30 months. Recommendation is to authorize formal and send consent order with a civil penalty in the amount of $3,000, which is $100 times 30 months of working unregistered in violation of TCA 6232-312D.
I make a motion to concur with council.
Okay, we have a motion by Mr. Tucker. Do we have a second?
Second.
Which one wants to go? A second by Mr. Roberts to concur with council's recommendation. All in favor voice by saying aye.
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 All opposed, motion carries.
Case number 2013-011191. Complaint was established when a letter from respondent was submitted to board office which failed to properly display the certification number per TCA 6232-316D. Respondent states this was an oversight and new procedures have been put in place to ensure this will not occur in the future. My recommendation is to issue a letter of warning to respondent company regarding properly displaying company certification number on all correspondence.
Madam Chairman, I make a motion we concur with the recommendation of our council.
I second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Tucker to concur with the council's recommendation. All in favor voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-011201. Complaint was established when a letter from respondent was submitted to board office which failed to display the certification number. Respondent states that on the original form, certification number was printed on the back and new letterhead has been developed to display the certification number on the front to ensure this will not occur in the future. My recommendation is to issue a letter of warning.
Make a motion to concur with council.
Okay, we have a motion by Mr. Tucker. Do we have a second?
Second.
And a second by Mr. Harvey to concur with council's recommendation. All in favor voice by saying aye.
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 All opposed, motion carries.
Case number 2013-012471. Complaint was established when a competing properly licensed alarm systems contractor alleged that respondent was engaging in business of installing access controls and CCTV without being properly licensed. Respondent states that it does not directly sell or install access control alarm systems or CCTV. They do advertise some security products on their website. However, since the initiation of the complaint, they have placed a disclaimer on the website stating that they do not directly sell or install these systems and that all such sales and installations are handled by properly licensed alarm contractors. The respondent does engage in the business of integrating phone systems with existing or planned security systems. My recommendation is to issue a letter of warning to respondent company regarding obtaining proper licensure prior to holding oneself out as engaging in the sales or installation of alarm systems without proper licensure.
Do we have any information that they actually did sell or install alarms? It was just the complaint from
No, ma'am. It was just a complaint based on what was stated on the website.
On the website.
And now I've checked the website, and that disclaimer has been placed there, and it looks like they're not doing any direct installation or sales, from what I could find.
Make a motion to concur with council.
I second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
A little aside here, complaint or case number 7 through 10 are all essentially the same violation, and that is regarding properly filling out the registration applications for employees. And I'm just going to go through one to give you an idea. Properly licensed alarm contractor failed to timely register one employee, and their explanation for this oversight is all essentially the same. Respondent states that it deals in other aspects besides fire alarms, and that employee was originally hired in a different capacity that did not require registration, and the date that they put on their registration application is the date of original hire and not the date hired and registered position, which is what the form actually says. But based on the number of complaints on this report for the same violation, I think that maybe in these cases, since this is their first infraction that I could find in RBS, for this violation, I believe a letter of instruction to the respondent companies regarding what the date hired and registered position portion of the form and how it should be filled out in the future to avoid future complaints might be in order. And I wanted to run this obviously by you and see if you don't agree with that we do. I don't know if you wanted to do a letter of warning or if you wanted to do the usual $100 for failing to timely register. I mean, the form, I think, is pretty clear in that it says date hired and registered position, but based on the volume of complaints we've had for the same thing, I don't know. I think maybe a letter of instruction might be in order here.
Oh. And I guess the question would be, what did they say they hired these employees as?
It varies. Some of them were hired out of state, and when they started working in Tennessee, they registered them, and then
That could
other
happen.
aspects of like sprinkler systems or other things that are not covered under the alarm, cable installation. And
So
we
all
don't
of
have,
these-
I'm sorry.
What you're saying, all of these, they put the original date of hire and not the date of requirement for a licensed employee, correct?
Right. In all cases, they put original date of hire instead of the date that they were promoted or transferred to the registered position.
That probably could be the employee put down that date and whoever's overseeing it didn't look at the date, so that could happen. And you got 4 of these, I take it.
Yes, sir, 4.
4 different employees
Right.
as well, okay.
Were the 4 different employees with 4 different companies, or the same company?
It was 4 different companies, which is why I'm leaning towards letter of instruction, because obviously this is a point of confusion for more than just one company.
I personally feel that a letter of warning is appropriate in these cases. I believe it's been the board's perhaps unwritten policy in the past that really our desire is to bring people into compliance rather than trying to kick them because of some sort of clerical error. So I think in each of these cases, a letter of warning, especially where we've not had a problem with these companies and previously, would be appropriate.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with the council's recommendation in these 4 matters. All in favor, voice by saying aye.
Aye.
All opposed, Motion
Josh,
carries.
excuse me, Josh, why don't you read those case numbers so we've got those in the record?
Yes, sir.
Even though we've already voted to concur with your recommendations on all four, I think each one of those case numbers needs to be listed.
That was case number 2013-015351, case number 2013-05361, case number 2013-015561, and case number 2013-015761.
Yes, all of those were to receive a
Right.
letter of warning.
Case number 2013-015411. Complaint alleges that respondent failed to timely submit 8 termination notices. The date of termination noted on the forms is October 15th, 2012. Notices were received in the board office on May 13th, 2013. Respondent states that he sold his company to another larger company who promised to keep current employees on after the sale. Respondent admits that he should have submitted transfer notices at that time, but new company agreed to take care of the paperwork. Respondent admits he should have followed up to ensure that they did as promised. Respondent was still listed as the company DQA at the time of the sale and was still responsible for the notices. Therefore, my recommendation is authorize formal and send consent order with a civil penalty in the amount of $400 for failing to timely submit termination/transfer notices for 8 employees.
Did these employees actually transfer? Do we know? And where I'm headed with that is, does the company that bought, the larger company that bought the smaller company, do they have some responsibility in this as well?
Well, according to his explanation, they verbally told him that they would keep him on and do the paperwork, but he admitted that it was still ultimately his responsibility. And I believe that I don't have any evidence to know one way or another whether they transferred to the new company, other than, he submitted 8 termination notices from his company.
It would seem to me that the acquiring company would potentially have been at fault here to some extent. Now, the fact that they verbally promised the acquired company that they would do that really doesn't have any bearing as far as we're concerned. But if the employees actually went to work for the other company and they were not transferred or signed on as a new employee, then there's a basis for further action on that with the company, the larger company that acquired the smaller.
Do y'all have record of the larger company registering these employees?
They're based in another state. I don't know. I don't.
According to y'all's records, these employees are no longer registered in Tennessee with another company.
Right. So, are they still, so the old company is terminated, it's shut down?
It's still active, isn't it? He's still, the QA and the company are still
well-
active.
Okay.
I think he just sold his accounts. I don't know, but the new company has never applied for anything that I'm aware of.
So if he just sold the accounts, the old
They're in
company's still
another
active?
state.
Well, it
The-
says he sold his company. It don't say his
The
accounts.
employees don't need to be transferred. They're still in the old company.
Are both these companies out of state?
Registered employees with the new company.
Let's let
can,
Attorney Kilgore look at the file for just a moment. Perhaps he can.
Just a moment. I apologize.
I believe we could probably move on with this. I would personally believe that the council's recommendation for this particular case is fully appropriate. I would think, however, that there should be some follow-up to see if there is some responsibility on the part of the acquiring company. So what I would do is I would be willing to, Madam Chairman, make a recommendation or make a motion that we concur with the recommendation of the council, which would authorize a $400 penalty to this particular company. But I also feel like that it would be appropriate to follow up and see if the acquiring company had some responsibility either to transfer or license or register the employees in question. And that can be done at maybe you need to set another complaint on that or investigate it further.
Right.
That could be handled later without a problem.
And I believe after reviewing the file that would be appropriate to establish a complaint against the acquiring company.
Right.
I just had a moment to see who the acquiring company was, and
Tennessee company?
I believe that they are, or at least they do operate in Tennessee, so that would be something worth.
They may have done everything completely and fully appropriate, but we can investigate. You could investigate it
Because
further.
the last guy was trying to do the right thing, but what happened is they never got
They never got
They never got
properly transferred
transferred,
to the
period.
acquiring
the
company.
acquiring company hasn't.
Which they wouldn't have to if that company wasn't in Tennessee,
Right. They would have to if they're still
working in Tennessee.
working in
Working
Tennessee,
here.
I
right?
made a motion
Right.
to concur
So
with the
it's,
recommendation of council.
I'm not so sure that the fellow did
Yeah,
anything
I
wrong.
think this case can be settled.
But that means the old company is current, correct?
The old company is still operating.
And they're still current. and
It's
they're-
that he sold some accounts over to the larger company, and along with those went apparently these employees.
There's something
So,
missing.
it's my
Yeah.
understanding, this,
Something missing.
He had a dealership that was authorized to sell one particular company's stuff, and when he sold that portion of his company, he's not authorized to sell that equipment anymore. And I guess that those employees were only authorized to sell or affiliated with that company, and that's why only those 8 were supposed to be transferred over to the new company.
and close his business down. He just sold off a portion
A
of his
portion
company.
of it. And I'm sorry for
No,
the
that's okay.
confusion, but just reviewing it, I see that that's actually what happened.
We have a motion by Mr. Roberts to concur with our council's recommendation. Do we have a second?
Second.
Okay.
We have a motion and a second. A motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Now, I would assume there'll be a new complaint issued to investigate the.
Yes, sir.
Sure. That's the thing to do.
Case number 2013-015341. Complaint alleges that respondent failed to timely register one employee within the 30 working days of hire as required by law. Respondent states that steps will be taken to ensure that applications for registration will be timely filed in the future. No prior disciplinary action was found against this respondent, so my recommendation is to send a letter of warning regarding properly and timely registering employees within 30 working days.
Second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-015391. Complaint alleges that respondent failed to timely register one employee within 30 working days of hire as required by law. Registration application states the employee was hired January 7th, 2004, and was not received in the board office until November 28th, 2012. So the company failed to register an employee for over 8 years through 4 renewal periods. Respondent states that an internal audit discovered the error and application was submitted immediately upon discovery of same. However, after examining the 2010 renewal application for respondent, it was observed that there were only 3 active employees listed thereon. Being that there are so few people to register, it's hard to imagine a fall through the cracks situation in my mind. My recommendation is to authorize formal and send consent order with a civil penalty in the amount of $8,000, which is 1 employee working 8 years unregistered at $1,000 a year.
How many employees are registered with this company? Is that something you,
I believe it.
The complaint
Oh,
here
it
says
says
3.
3.
It's 3 in the body of the.
I guess the way I'm hearing that, it sounds like there's 3 registered, but there's more people who work there,
Well, at least this one. I mean, that's all that we know
have
of.
been registered.
Right. I mean, I guess the reason, and I'm not trying to be casual with the fall through the cracks language there, but I mean, if it was a larger company with 200 or more employees,
We have an issue
I could
there.
understand,
They,
but
they know that
I
guy's
don't-
not registered.
Do we have a motion about?
Madam Chairman, I make a motion that we authorize a formal hearing and send a consent order with a civil penalty in the amount of $4,000 rather than the $8,000 recommended by council. And the reason I'm doing that is because I feel like that this was based on discovery by the company. They have come to us basically saying, hey, we forgot to do this, and we're trying to bring it. They brought it to our attention. So I would recommend that we authorize a civil penalty in terms of $4,000.
Is that correct? It was self-reported, Josh? Or was it from another person? It was self-reported.
in the response, it states that the oversight was due to management and ownership changes. And it looks like they did self-report on their,
Did the qualifying agent change in this company? Is that a yes or no?
I don't know without looking. It does look like this was discovered based on the application for the employee that was sent by the company, obviously.
Second would be to turn to go down to $4,000 and bring it.
Yes, Mr. Roberts' motion is to concur with council's recommendation other than to reduce the civil penalty from 8 to 4,000. So do we have a second based on Mr. Roberts' motion?
A second.
Okay. We have a motion by Mr. Roberts to concur with council's recommendation in every aspect except to reduce the civil penalty from 8,000 to 4,000. We have a second by Mr. Harvey. All in favor, voice by saying aye.
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 All opposed, motion carries.
It looks like they did go through a QA change sometime.
Still for renewal, but okay. Case number
Right.
2013-015861. Complaint alleges that respondents' representatives held themselves out as representatives from a competing alarm systems contractor company when contacting said competing company's current customers. Presumably, this was done in an attempt to get people to sign respondents' contracts before customers knew that they were dealing with a completely different and unrelated alarm contractor. Respondent states that it does not sell systems but merely monitors them. Respondent forwarded complaint to the alarm contractor that is an authorized dealer for it so that the proper party could respond. In response, authorized dealer states that it contacted the agents named in the complaint and provided more training to its entire sales staff to specifically address this problem. Sales staff was told to ensure customers knew and were informed that their company was completely separate from their current alarm providers. No specific customer names were given by complainant to verify any of the allegations made in the complaint. Respondent has stated that remedial measures, i.e. additional training, were taken to ensure that similar complaints will not be filed in the future. My recommendation is send a letter of warning regarding dishonest dealing per TCA 6232-319D.
Madam Chairman, I will make a motion that we concur with the recommendation of council.
I'll second.
But I would also add that I feel that the council, in addition to the letter of warning, needs to send a copy of the code of conduct that the board has adopted so that the company is fully aware of that as well.
Okay. We have a motion by Mr. Roberts and a second by Mr. Tucker to concur with council's recommendation with an addition of sending a copy of the board's statement of conduct along with this letter of warning. All in favor, voice by saying aye.
I'm assuming that you mean the rules that we have. The code of conduct has not been officially implemented into the rules as of today. It's still making its way through the process.
Send them a copy of it anyway. I don't think it would be anything wrong, even though perhaps it has not made its way through the rules change. It's in process, and the company obviously needs a copy of those.
Haven't had a official rulemaking hearing. It's been presented. They've been presented to the board, and it's been authorized to move forward, but it hasn't been.
Well, just tell them that
officially.
it's in the process of being adopting then. But still, they need a copy of those, obviously. It's part of the public record of the board, even though they may not have been gone through the full adoption process.
Well,
We have a question.
the question that I have about that is if it gets changed in the process and it hasn't been officially adopted, are they to abide by things that haven't been officially implemented into the alarm board's rules?
It's still something the board has adopted at this point, even though it's not in the rules, perhaps not enforceable. I'd send it to them for information purposes. It really goes into a good deal of it provides important information so the company can start modifying what seems to me to be a highly deceptive practice. I think they need that information. I really do. You can, even though it hasn't gone through the rulemaking process, you may want to provide that information. But I think the company needs
Because there's
that.
no harm in telling them this has not been adopted yet, but
That this is in the rulemaking
Board
process, or
recommendation.
you can provide appropriate information with that, but they need a copy of that. They really do.
The motion carried. We did get the vote. Number 15, I think, Josh.
Case number 2013-015741. Complaint alleges that respondent failed to timely submit one termination notice within 30 days as required by law. termination notice for employee was received by board office on May 28th, 2013. The termination date indicated is January 11th, 2013. Respondent states that previous licensing person deleted some critical files and left some paperwork behind. Respondent found this error while going through old files and filed upon her discovery. However, respondent has been the DQA for this company since approximately 1995 or 96. My recommendation is authorize formal and send consent order in the amount of $50.
Make a motion to concur with council's recommendation.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-015401. Complaint alleges that respondent failed to timely submit termination notices within 30 days as required by law, or failed to properly list employees required to be registered on company renewal form. Respondent states that in fact 2 employees were terminated and the forms were subsequently sent to the board office within the 30-day time period. The only failure was not listing 1 registered employee on company renewal. My recommendation is to issue a letter of warning.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
I'll second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-015751. Complaint alleges that respondent failed to timely submit 1 termination notice within 30-day time period allowed by statute. Termination date, as mentioned on termination form, is January 7th, 2013. Was not received in the board office until May 16th, 2013. This is the second violation for same infraction against this respondent. Recommendation is to authorize formal and send consent order with a civil penalty in the amount of $100.
I'll second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-016911. Complaint alleges that respondent company failed to register 1 employee requiring registration within the 30-day time period allowed by law. Respondent admits this was an error on their part and they will be more vigilant in the future. Employee registration application was received by the board office on May 30th, 2013. Respondent's hiring date is listed as February 25th, 2013. My recommendation is to authorize formal and send a consent order in the amount of $200 for failing to timely register 1 employee for a period of 2 months. In line with our regular guidelines.
Make a motion, concur with council.
We have a motion by Mr. Tucker, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-016831. Complaint alleges respondent failed to timely submit 1 termination notice within 30 days of termination as required by law. Respondent states that employee in question quit upon finding other employment on October 6, 2012, but told them that he would stay on as a as-needed basis. Respondent states that they made the decision to officially terminate employee on April 15, 2013. The date listed on the termination form is October 6, 2012. And then on April 16th, 2013, the board office received notice of the employee's termination. The respondent has been licensed since 1998 without any disciplinary action. My recommendation is a letter of instruction regarding the importance of properly filling out termination notices with stress on the fact that the actual date of termination should be listed to avoid further complaints.
Madam Chairman, I make a motion we concur with the recommendation of our council.
I'll second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-016851. Complaint alleges respondent failed to timely submit one termination notice within 30 days of termination as required by law. Employee in question was terminated on April 20th, 2012, and termination notice was received in board office on March 19th, 2013. Respondent states that the failure to submit termination notice timely was an oversight. My recommendation is to authorize formal and send consent order with a civil penalty in the amount of $50.
I make a motion to concur with council.
Second.
We have a motion by Mr. Tucker, second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-00721 and 2 and 3. This is a little bit lengthy, but I think it all boils down to a contract dispute, which we normally don't get in the middle of. But complaint was established when complainant was billed for an alarm system that was never installed. Her credit card statement indicates the supposed alarm system installation was billed under an unlicensed company name other than the one which respondent is licensed to engage in alarm contracting. Complainant states she was approached by an employee of respondent who talked her into, quote, upgrading her security system on more than one occasion outside of her condo where no soliciting signs are posted. Respondent owner states that employee in question does not sell alarms but hands out flyers advertising for his company and solicits satellite sales. Respondent employee states he was merely doing door-to-door handouts on products his company provides, but at no time was he selling any product. Both of those pieces of information are on a affidavit. Respondent owner stated that there was never a contract and that he did not know why he ran complainant's credit card. As she canceled her installation, he later refunded the money in the total amount of $1,380. Employee in question had submitted an application, and there is no evidence as to how long he had been employed in a position that requires registration. Employee had made several applications to the board, all of which had been denied for various reasons. The most recent application had not been denied when this activity allegedly occurred. And the other matters here appear to be contractual business disputes that are generally not in the board's purview. Contractual matters are generally best resolved in general sessions or civil court. Therefore, based on the lack of evidence to support the allegations, I recommend a letter of warning to respondent companies regarding 1, engaging in alarm business under the name which they are properly licensed, i.e. not billing in the name of other uncertified company, and 2, properly registering all persons engaging in alarm sales in a timely manner prior to them engaging in said sales, and a letter of warning to respondent employee regarding being properly registered prior to selling alarms.
So the company that charged the credit card was an alarm company.
Well, the company that charged the credit card on the statement, it was not in the name of not the business name that he's certified to sell alarms in. He has another unrelated business, and they're both apparently pretty small businesses, and he runs them out of basically the same location, it appears.
So
So the credit card machine was located at the alarm business / other unrelated company.
Which company is licensed?
Well, the alarm company is licensed. The company that it was billed under technically is not licensed, but it appears to be a pretty small operation. And on the credit card statement, obviously it confused the consumer when this unrelated business, which I believe is something to do with furniture, billed her for
I'm sorry.
the $1,300 something instead of the alarm that she apparently didn't want.
Guess I'm wondering what's going to be in this letter of warning, because that sounds That doesn't sound right. Something's. But he did give the money back, so I don't.
Right.
But that's.
I believe
Still in
flaky is the
satellites.
word.
I believe there's some unauthorized activity as well.
With a recommendation to council.
Yeah.
Second.
We have a motion by Mr. Harvey and a second by Mr. Roberts to concur with council's recommendation. All in favor of this motion, voice by saying aye.
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 All opposed? Motion carries.
I
I
started
was trying
struggling
to
with that one
find
myself.
some
so-
type of fine to go with that. I'm sorry.
Do I, Josh?
I went back and forth on that one myself, to be honest with you, but I believe in the
not-
end that this is probably the best route.
Furniture company.
Word for it.
I have one case for representment that the board had asked me to do some further investigation into, and that's on the separate sheet of paper that I had passed out prior to the meeting. This case is number 2013-010611. This complaint was previously presented to the board where it was determined more information should be obtained by board counsel regarding how long respondent alarm company had allegedly been operating without an alarm license. Upon further inquiry, it was determined that the location in question is not open to the public and is simply a location where employees have access to pick up their work orders. Respondent is a properly licensed out-of-state alarm contractor. It appears this location does not fit the definition of a branch office under the Alarm Act. Therefore, my recommendation is to close.
Concur with council.
I'll second.
Motion by Mr. Harvey, a second by Mr. Tucker to concur with council in this matter. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Motion carries.
Appreciate the follow-up on that.
Yes, thank
Yeah,
you.
thanks for the follow-up.
I think it shows a proposed rules update.
The rules, after I presented and got the board's authorization, I went ahead and got them drafted and they're up the chain for approval. I've sent them to Michael Driver for it has to go through him and then on up the chain. And that's all the information I have about where they are at this point. Have not heard back from where they may be right now, but I will follow up and at the next meeting should have an update further on that.
Thank you.
Thanks.
Right, okay. This meeting's we're gonna take a recess for 15 minutes.
Too much information.
Okay. Our meeting's gonna be back in order again. Next item on the agenda is the open complaint report. Is this correct, Ms. Vest?
Yes, but I'd like to make a couple announcements before that, if I can. First of all, I'd like to introduce you to some of our new staff members. Well, today with us, we have, I don't remember whether you have met Tony Kerr or not. She is actually with the Alarm Board, works with our registered employees. She's a lady in blue. And then the lady sitting next to her is Jackie Cunningham, who is with the Private Protective Services. So we
Could-
wanted to come down and see a board meeting and how it's conducted.
We can't even see him. Oh, right. Oh, okay. Oh, okay. Hey, how you doing?
The administrative manager has been promoted, so now we do not have administrative manager. So it's going to be falling back on Beth and I until we get that position filled. One thing. Second thing is I'd like to thank the board for coming in, helping us with these exams. I personally think it went a whole lot easier than I had anticipated it would. I believe we allowed ample time, maybe a little bit too much time, but I'd rather we had ample time than not enough to conduct the exams. But I wanted to thank you personally coming and helping us and working with us, and I think we conducted it in a professional manner, and we were able to get good at that time to have their exams. A little update on that is Beth and I and Josh met with PSI, who is going to be doing the exams. We met yesterday, wasn't it? Tuesday? It was Tuesday. Okay, days running together. And we're right on schedule. I think we're a little ahead of schedule. So we hope to have an announcement pretty soon when the applicants can start registering. What we will do, we will notify everyone that we have an application on file now personally. We would do it by phone or email, however we can get a hold of them, tell them it's time, send them all the information, and then, of course, we will have it placed out on our website. That's a little update on that. You would, now you can turn to your Exhibit B, please. We're going to go skirt right through this because we have this every month. You have on there 49 complaints, and this morning you closed out 22 of them, leaves 27. You have 4 more hearings authorized. Attorney Simpson has got several of those already in process that we're going to be notifying you of and giving you different dates. And you do have a date. You go on record and tell you do have a date already scheduled for formal for the March 14th of 2014. Last time I had talked with Attorney Simpson, I believe there was 3 of them, but I don't. Let's look up there for November the 15th. Just finger moved down to the new year. We do have 2 that I know of that's scheduled for November the 15th. But we're moving on those quite well, quickly as too. And we'd like to thank our attorney Kilgore here for working diligently on getting these complaints under control and working with us with those. So let's look at of course you've already looked at the open complaint report. If I can get now of course stop me and ask me. Not get my. Go ahead and sit back there because I. Okay, we'll just move. I don't want that. I'm past that. I want the next one to move. Okay, we're past the open complaint. Let's go to the disciplinary report. You have July and August. I believe this information has already been sent out to you, so we've already reviewed it. And if you got it?
I haven't sent this out.
Okay, well, let's look at July then, now that I've got Hannah, thank you for helping me with that. We'll take a look at the disciplinary report. Do you have it up there, Beth, or have you been able to get it up there?
It's
Okay,
just something's
we're
wrong with my
having
laptop.
technical difficulty. We started off like that this morning, so it's gonna go all the way through, I'm afraid. Okay, the July, as you can see there, the first one, of course, is your your alarm system contractors board for the civil penalties for July. Included in this is our other programs, and then you have your August make a statement here. I think you can see hear from the complaints you had this morning, and you can see from this report actually a lot better. We're having problems with getting these termination notices in, or these transfers in. How much plainer to make it in a registered position, and this is the state of Tennessee, and you got a Tennessee application. I mean, if there's any suggestions, since you are in the business, I'm willing to listen to it, try to change whatever needs to be changed to try to help the industry here, but to continue finding them, and it's not always the same company, so is there a problem? If it was the same company over and over again, we could address that, but it apparently is different companies, and not just large companies. But I just wanted you to look at that.
I really think the situation, especially with smaller and middle-sized companies, that don't have someone that's dedicated to look after that particular situation. They're just busy trying to do business and look after their company and their company's business, and they once a guy's gone, or an employee's gone, why they're kind of out of mind at that point. And
Mr. Roberts, don't we hold the qualifying agent responsible?
yeah, we do. But again,
So,
especially in
I
the
just
small,
is there something else we
That's
can
where the
talk about
pressure is
later
going to come from.
Yeah.
and you know, our procedures for a letter of warning and fines, graduated fines, I think is reasonably appropriate. It's just people are. Again, once the employee is gone, then that employee's out of mind, and the people running the business are trying to run their business and make a living. It just gets overlooked. It would be a lot easier to overlook terminating an employee than it is to register a new employee. Because when you've got a new employee coming to work, then there's that employee. You're seeing that employee every day. You say, oh yeah, I gotta get this person registered. But once an employee's terminated, he or she's not there any longer, and it's pretty easy to forget. I don't think we have a problem with our procedures, and frankly, I think our letters of warning and the penalty structures that we set up as guidelines are graduated, so that if they do it once, we send them a letter of warning. If they do it a second time, then there's a fine involved, and if they keep doing it, there are larger fines involved. I really think we've got a reasonable procedure.
All right, thank you. I just wanted to bring that to your attention. That seems that volume that we have. Okay, monthly reports for July and August would be D, but you do not have D on your iPads. Okay, so let's just skip right over that if you don't mind then. And what I'd like to do is go ahead, we'll get that clarified, and maybe we'll come back to that. If you would, we would just go ahead and go into the correspondence review, which would be E. E, F. Give you a few minutes to look over that. This is a request for an out-of-state developer for mobile applications. These telephone companies or cable companies, I don't really know how to address a lot of this, so that's why I've asked for them to writing that they want you to look at. They want you to look at their letter and see if they need to have a license. It's a license requirement. We in this office were not able to answer that question. we didn't lose that.
Well, that's why I put it up there. I didn't want to put it in the bottom.
Believe it might be, I might need to read this into the record so that everyone knows what we're looking at,
Not getting
since
on
we
the
can't
board.
put it on the board here.
I'm trying.
This is a letter that appears to be from a law office representing a software developer who has developed an app. It says, "Dear Ms. Vest, we represent an out-of-state developer of mobile applications, the developer that has created a safety-related video conferencing application for smartphones, the app. The developer desires to make the app and its services available to users in Tennessee and requests clarification regarding the act as applied to the app and the services the app provides. Set forth below are the relevant facts together with several issues on which we request guidance. We do not believe the act applies to the app or the services provided in connection with the app. Accordingly, we respectfully request a determination from the Tennessee Alarm Systems Contractors Board, the board, that the act, including any requirement regarding licensure or registration, does not apply to the developer or app." Part A, facts. The app permits smartphone users to contact a friend or professional safety responder if they feel unsafe or in an emergency. The app uses the phone's video conferencing feature to enable the user to communicate with a friend or responder. Once connected, both the user and the friend or responder can see and speak to each other. The user can then point the phone at the scene around them or a potentially threatening person to transmit video and audio to the friend or responder. The friend or responder appears simultaneously on the phone's video screen and can communicate directly with the user or threatening person over the phone's speakers. The friend or responder can then tell the threatening person they are being recorded and instruct them to walk away from the user. If necessary, the user or responder can also contact 911. The phone's GPS permits police or a safety responder to locate the user. Video and audio may be recorded on the device with backup on a remote server, which is available to police if requested. The responder may be a call center dispatcher, a guard, or an off-duty police officer working in a call center or similar facility, likely to be in a different state and who may appear on the phone's video screen wearing a security uniform. And B, request for determination letter. We respectfully request board provide a determination regarding following questions. 1, the app is software, not a mechanical, electrical, or electronic system, or any combination of those systems. The app itself does not detect any emergencies, 2, record, view, monitor, protect against, avoid, or reduce the probability of any loss, injury, or intrusion, or I guess that's supposed to be 3, summon aid for any emergencies. Rather, the user must detect an incident and use the app to record an emergency event and call a friend or responder for assistance. Finally, the app is not tied to a particular premise, but is intended to provide personal safety services against physical injury and is not limited to the property crimes enumerated in the act, i.e. burglary, theft, shoplifting, pilferage, or other losses of that type. Under these circumstances, A, does the app constitute an alarm system as defined in Tennessee Code, annotated 6232-303-1. B, does the developer constitute an alarm systems contractor as defined in Tennessee Code, annotated? And 2, does the act including any requirement regarding licensure or registration apply to the developer or app or persons working for the developer or app? Thank you for your attention to this matter. I appreciate your assistance. If you require any additional information or have any questions, please do not hesitate to contact me. And that's by Alan Wong. Novel question. to say the least, I think.
The thought is,
A lot of difference in that and some stuff that's already out there.
Biggest question was, who is the professional safety responder? Wouldn't
Um,
that,
here-
shouldn't that be a certified central station or something?
Here's the way it could be anybody, I would guess. Here's the way I look at it. The app in itself, it does not constitute an alarm system. It's a
Right.
piece of software. However, the app in conjunction with the telephone or smartphone may constitute an alarm system. The app in conjunction with the telephone is clearly intended to help respond to some sort of an emergency condition. Secondly, I would think that if the system that consists of the app and the telephone contacts a designated professional responder, then the designated professional responder to me would be fairly clearly providing a monitoring and recording service. They have indicated the recording is part of the overall system. So I would think that if they are selling an app, that does not constitute an alarm system. That is something that the board needs to be concerned about. But the responder, a designated professional responder that is contacted, to me appears to be providing a monitoring and response service. So the answer is yes and no.
That, and I guess the part that kind of concerned me, not only like Mr. Roberts was saying, the responder, but also they have access to the phone's GPS location, which would be, in my mind, sensitive information that would require, I don't know if you'd want every person out there, strangers, to know your GPS location and be able to locate you. Is that, so do you think that the person responding to the call needs to be registered?
I would think that yes, if this system, as we define in the system, the app plus the telephone constitutes a system. If the system contacts a designated response agency, then that agency, whether it be however they've got it set up, that should be considered a monitoring service, and that they're providing a monitoring function. Now, if on the other hand, this app and the smartphone just allows the individual who feels threatened to contact 911 or contact a local police department rather than a designated professional responder, then if it just, under those circumstances, there's not a monitoring service being provided. But it would be my assumption that what this particular letter is focused on is the response agency providing a monitoring, a monitoring function for this system as we've defined it. And I'm assuming that there would be a monthly charge or some sort of charges for that. Again, that we don't, as a board, don't care whether they charge for it or whether they do it for free. That's not material to us. But I would think that a designated professional response agency is providing a monitoring function. What does the rest of the board think? It's my opinion.
App alone, no,
It's-
but in combination, yes.
I mean, how does, if I get the app on my phone it's turned into some type of security that you feel you got. Bigger question is, if you couldn't talk and you, how would you report it to 911? It's a bigger picture than what we're doing. If you understand what I'm saying, if you get this app on your phone and somebody is attacking you and you can't say anything, all you're doing is basically hitting this button. You're not going to. Do the police departments want to answer these calls or whatever? Because you're not going to be able to verbally say that much if somebody's up on you. You guys understand what I'm trying to say? If somebody is attacking you and you're using this app, it's going to get bigger than us. Police departments want to know, how to respond to it. Yeah, we got something going on here. It's just going to be a gray area. Are you saying you want to register, or it's not an alarm, but it's
Well, the company,
Well, the app's not an alarm.
No, the app's
not
an
Like you
alarm.
said,
But it's
when
being
you have
used as one.
In conjunction with the phone.
Right.
And it goes to a monitoring, monitoring center. Yes, it does become,
it becomes something that's monitored.
see, that's what I'm saying. We don't have an alarm system here. They can sell it, they can provide it, but if there is a monitoring type of service provided, and that's what it appears to me,
We
is-
need more communication from them about what specifically, I mean, I know what it says here, and it looks like it might be a monitoring situation, but, after.
They
I think
vary.
it definitely
they
is a
vary.
monitoring, because it uses a different language. It says
Right.
off-duty officer working in a call center.
They
That's a
vary.
monitoring center.
Right.
If this was an app that when these circumstances arise and you activate that app and it calls 911, that's different. But you're going through a second or to a third party to even get help. Excuse me.
They very carefully worded their letter
Yeah.
to avoid using monitoring or response agency, something like this. But where they are recording this, they would, in my opinion, be clearly providing a monitoring function, and would need to have that with registered and licensed.
That's kind of ambiguous
individuals.
too, because one part you read, it may be recorded on a remote server, but, oh, no, there's no recording. Yes, there is. You define that it can be recorded, but then it's not. So,
I didn't know if it was just recording to the user's device, or I'm assuming that
That's
it's probably
to-
recording to their, right, so, I mean, I'm not disagreeing with you, I'm just saying it probably will require, just saying, this is what the board recommends if you're doing this, and
yeah,
putting
if
in
it's
some.
going through a
Right.
call center, whatever they want to call this, if it's notifying a call center, then yes, that's the same in our minds as a monitoring center. That's right, more.
Tell them, send them a letter saying
I-
we feel like
You
it's
know,
a
again,
monitoring.
I
center.
would feel like saying that we do not consider the app an alarm system. The app in conjunction with the telephone may constitute an alarm system. I wouldn't really want to push that point, but it would appear very clearly that they're providing a monitoring function with a designated professional response of some sort. Now, if the app just called 911, then I wouldn't be concerned about it, because that's a direct contact between the user and the 911 center or the police department or whatever, fire department. But if this goes through a designated professional responder, then it would appear clear to me that this would be a monitoring service, and that that it would require licensing and registration. Now, if they feel otherwise, I guess they could come and present their case that, oh no, we're not providing a monitoring service, we're just doing something else. But it appears clear to me that they're providing a monitoring function.
The app itself is,
Yeah,
okay
I
that-
can,
App, you can sell.
Go ahead.
They can do what they want to do with the app, but
Oh, yeah.
it's the responding party
right, right.
notification. to the
notification
responding party.
would be monitoring. But like I said, the bigger problem will be is when they start having problems with that. That's a gray area.
I would make a motion that we respond to this letter. And I would let our staff attorney provide the exact verbiage, but basically to the effect that we do not consider the app an alarm system, that the app in conjunction with the telephone may constitute an alarm system, but that if the system contacts directly a designated professional responder, that we would consider that designated professional responder or response agency as providing a monitoring service, which would need to be registered and licensed under Tennessee statutes.
Okay. We have a motion by Roberts to say that we do not think the app is an alarm system, but used in conjunction with the phone, it could constitute an alarm system. And if the device does contact a call center or a designated safety responder, we do feel like that have a second.
Second.
We have a motion and a second. All in favor voice by saying aye.
Aye.
All opposed, motion carries. And that was Mr. Roberts and Mr. Harvey, Beth. I'm trying to remember to read it out for you.
Let me sort of follow up on that just a little bit. I indicated that I used the word may in terms of an alarm system. As I would envision what this letter proposes, that they're going to sell the app remotely, maybe offered in a variety of different ways. I would not think that this app as such would require registration for somebody to sell it or licensing in any fashion. I just don't see that as part of what we would be involved with. So if they want to sell it over the television advertising or door to door, they're basically selling a software application, and I would not visualize that as requiring licensure or registration. I didn't put that in the form of a motion because I don't, that's just kind of a clarification.
Do you have it, Beth? Yeah. Okay. Josh? We'll move on to F then, if you would, please. This is to replace the designated qualifying agent for FTS USA. They had, this is their third request, let me word this properly. This is the third request for an extension because we do not have any exam in place.
Didn't come up and take the test the other week.
Only people that took the test is the ones who had previously
she's-
had applications on file.
Oh, okay, I mean,
for a
he didn't
while
have-
back. He
okay.
didn't fall into that bracket.
Okay.
Let me ask staff, do you have any reason that you can think of why we should not grant this particular extension? It would seem to me to be a valid request.
This one, F and G, both are the same, is the qualifying agents had to be replaced, and there is no exam in place, and they're asking, whatever reason, they didn't get into when we did the in-house testing, whether several people couldn't come, or illness, or whatever, they couldn't get in. personally don't know. As the director, I don't see any reason that we could not extend this.
Not any particular negligence on their part then. Madam Chairman, I make a motion then that we grant an additional 90-day extension to FTS as they've requested.
Motion by Mr.
Second.
Roberts, and we have a second by Mr. Harvey to grant this request for a 90-day extension by FTS. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, let's turn to G, and G is to replace the designated This one just might be just a little different, but it is still trying to replace the qualifying agent. It's just a time frame into you. The time frame was June the 14th of 2013. We got a termination notice from their previous qualifying agent. He left the company March the 15th of 2013. We got this letter to replace the QA for August the 25th, and of course there is no exam in place.
But this guy is just an employee with Honeywell?
There's no QA.
I know, but.
He's, I would dare say
He was, again, we got his application in June, but when I asked for additional information, he thought we were rejecting his application. He would have been eligible to come take the exam in August. And then the DQA for the Nashville Honeywell office contacted me to ask if he could be the QA for both offices, and I'm like, no. So they finally understood what we needed, and I said, you're gonna have to ask for an extension. So the guy in Memphis provided this letter because he really misunderstood, is what I think happened.
I
Hard.
mean, they initially applied in June.
Well, the company's had a license, if you look, their license number's 97.
I know that, but
They've
I
been
mean,
licensed since 93.
but I mean, it was, they initially applied in June, which shortens that time frame up a little bit.
See, their extension, if they had asked for it in a timely fashion, would have already expired. And now that he understands what he has to do to get in compliance, he's asking for basically a second extension.
Madam Chairman, I make a motion that we grant the extension, 90-day extension is requested by this letter.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to grant this company a 90-day extension to get a designated qualifying agent. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. ready for Exhibit H, is that correct?
Ready? I'm just giving you a moment there. Yes, if
Yeah, I
we
mean,
would.
well, let's give the board an opportunity to look over the file then.
Is there anyone here that's going to make an appearance that has not signed in? Is anybody here going to, would you please come in and sign in, at least we'll have that on. Here in the podium, sir. And give them just, yes, we'll go to H will be fine. Is he here?
You guys both already signed in when you got here.
Okay, good. I'm gonna do this while they're signing in. I'm gonna do these just a little bit different. I'm trying something new with these criminal records there. Some of them are extensive. So what I would like for you to do, instead of starting at the beginning, just turn to page 10. Is where I wanted to actually start. It tells you, he's telling you exactly the charges. He said, tells you on the application what the charges are. I guess I should tell you on the record, this is Exhibit H, and this would be Daniel Philip Chapman, Senior. Then it'll help you, then you can see right behind that, he does have a typed explanation, and then there are the listing of the different charges. Instead of trying to go through the whole record at one time, I'm going to direct you right to what they are saying that it was, and then what the record is. And right in the front, as you open it up, is a copy of the front page of the application and then the criminal record. But if you move, makes it easier to read if you go back to what the application itself is saying and his written explanation with the dates given for the arrest. Give them a few minutes, Mr. Chapman, please, to review the record. This is the first time they've seen the application. You'll notice in there, as you go through, he is licensed, if I'm not mistaken, in South Carolina, Georgia, and North Carolina. Okay. Chapman, why don't you go ahead and step up to the podium? I think we're about to that point. I do have a question for Mr. Chapman myself. Do you own your own company? Are you trying to qualify your own company? Okay. You don't have any employees yet?
Georgia right now.
Explain, maybe, we read something here, so maybe you wanna talk to us just a little bit.
Yeah, if you look at the felonies back in '83 and '84, my first child was born in June of 1983. In July of 1983, I wrecked the only car I had, and I was in sales. And they went along for I lost all my income, and they turned my power off and turned my water off, and I lived in a house raising a 3-month-old daughter with no power, no water, and heating her formula up on a kerosene heater. And I let some friends talk me into it. I'm thinking all I got to do is just make a little bit of money to get a car. And I did. I got influenced and made the wrong decision, but I will say this is I, on my own, turned myself in. I tried to get it back, everything that we had taken, even though there was other people involved. And then I just raised different. I didn't, I felt bad. I couldn't sleep. So I tried to make it as right as I could. I went through my probation, and then in 1989, on my first application for pardon, I received a pardon for those.
Tucker, would you move your mic,
I'm
please?
sorry. Maybe you want to talk about 1990, 1992. There was kind of something else happening here.
Yes, sir. In 1989, May of 1989, I married my wife, and I had 2 children, like I say, by previous marriage. So about 30 days before we are to get married, went back to court, and they increased my child support to $650 a month. At the time, I took home $850 a month. So I had to find other means. My wife was real young. Went trying to find some other incomes, went into a partnership with a gentleman, and we had some checks returned, and I had to take a lot of the responsibility, but most of them were business checks that just happened to be signed by me.
20 years ago, what's changed now? I know you're licensed in other states, and these just questions I'm asking, okay?
Biggest difference is in September 1995, I give my life to Christ. Changed my life. Finally understood what it meant to try to walk with integrity and with character, that your word would mean something, that I needed to leave something for my children that they would want to see. And the biggest difference was all I can say is it just changed my life. It turned my life around, and then in April of 1999, I had a gentleman introduce me to security. Was very gifted at it. I worked for a company for 30 days, and they offered me the sales manager's position. I worked for them for 3 did very good with it. My income tripled, and I found something that I really enjoyed doing. And in February of 2001, I started my own company in South Carolina, and that was my first license. And shortly after that, I became licensed in North Carolina, and then shortly after that in Georgia. But for 12 years, I've had my own company. Got an A+ rating with the Better Business Bureau. I've never had one complaint, not one. I've never had one warning or any issue from any state that I do business in. I've never had a complaint filed against me. I determined that, well, my pastor, when he ordained me, told me this, and it just made a powerful impact on me. He said, I don't care whether it's life, whether it's business, or whether it's ministry. He said, but you'll have to choose between your name and money. So when that time comes, choose your name. He said, a man with a good name can always make money. But he said, if you choose money, you'll never make enough money.
I don't have any more questions. I just wanted something to go with this that I'm seeing. Owning your own company, it's just a really positive thing here. And I'm going to let our other board members, these items are, they're old, but we are concerned. You don't have one? I think we let him make a motion to let him move forward on his license for the state of Tennessee.
Second.
We have a motion by Mr. Tucker and a second by Mr. Roberts to approve Mr. Chapman's appearance, or approve Mr. Chapman's application for a license in Tennessee. All in favor, voice by saying aye.
Aye.
Aye. All opposed?
Has Mr. Chapman met the other requirements as well, the examination and so forth? Okay, okay.
But we've overcome the criminal history part, correct?
Okay.
Now would be eligible. When we get the exam in place, you'll be eligible to take it.
I'll be sending.
Sorry.
I just wanted to clarify that because that wasn't clear in my mind. So we're just really approving his background rather than his entire application.
Yes, that's all we're reviewing. That's all you're going to be reviewing for the next ones. But, yeah, all right. Thank you. The next one that we have on the agenda is Exhibit I, but the gentleman is not here, and he was not able to bring his qualifying agent with him, so he wants to get off. We're taking him off the agenda. So we're going to go straight to J, which is Benny Lee Goings. Yes, okay. You've already signed in, are you not, Mr. Goins? You're already signed in, so if you would, let's give the board a few minutes to look this over. And if I counted these pages right, you can skip right on over to page 19, and it is the application where it is written, where he's written the offenses. And then behind that is sheets, actually typed up sheets of charges. And the records are behind that. That was Michael Baker, works in the commissioner's office. I don't doubt it. I don't doubt it, but you think they take me out. Madam Chair, I know we're right into the middle of the Exhibit J for Mr. Goings. I've been called away for a few minutes. Could I ask for a 10, 15-minute break?
We're gonna be, okay,
All right,
we're gonna be in recess for.
15 minutes.
Will 15 be enough, or you wanna go for 20?
Back in a few minutes.
How about, we're gonna take a 20-minute recess.
Back on the record, Hannah?
I think we're,
All right. Have you finished with, I've already reviewed Mr. Goins, and you're ready to speak to him?
Yeah.
They have reviewed. Mr. Goins, would you step up, please? And he has his qualifying agent with him today, Mr. Bish. Well,
No, it's not a problem. I'm sorry. I guess I've known George for years.
just say hello.
okay.
Okay.
your
Do we have any
microphone
questions for Mr. Goins, since
Go ahead.
you've had ample time to review his application? Yes, Vivian has recused herself. You're on the record for that, yes.
Well, as I was explaining to Vivian, I think she can still conduct the meeting as
Oh, most
long
certainly,
as
just
she
not
doesn't
vote.
get involved in the voting or the discussion,
Yes.
since she feels that that would be inappropriate for some reason. Mr. Goins, you wanna make a statement or comment? I mean, we've got, I'd hesitate to say a record in front of us. We've got a bunch of them. Would you like to make some sort of a comment that would perhaps help the board reconsider this particular situation?
Yes, sir. I guess so. I started having quite a few problems in the late 70s while I was still working with the Chattanooga Fire Department. I became drinking quite a bit and started having a lot of family issues. And was trying to, I think I was just searching for a different way to carry my life, and I got involved with the wrong people, you know. Got into some business ordeals that turned, sour. And I just went down the path of getting, like I said, I got into with the wrong people. I started drinking heavily. A few years later, I lost a son in a abduction, and he got killed. And I just lost it, and I turned to drinking to try to get comfort at that time, and to not turn into some type of violent person. I had been in the Navy and stuff in the past, and I just I lost it. I just lost it, and my problem then was driving. I would drink and drive quite a bit, and that's what really got me started. Like I said, with my drinking issue, I couldn't control it, but I have overcome that. It's been 13, 14 years or longer since I've had a drink. I don't drink. I've got my license back. I went through the judges, and that's how I got my felonies was driving. Mostly I wouldn't quit driving. I had to work. I had family, and I would drive, and then I would drink. I would leave work. We would go out and go to a bar, and we would drink. After working, I was working in construction at that time. I had a construction business and was doing good, but I just couldn't control my drinking. And I went through some quite a few personal problems, with my family. And it just, kept escalating at the time. And I developed some health issues, and I got to, because of my drinking and my blood pressure, my heart, and I just wore it out, and I got into a lot of different things like that, And like I said, my biggest thing, and I just couldn't man up, I didn't want to be that type of person, but I just, that's where I was. I was stuck there for quite a few years. And that's where I stayed until I got the Lord in my life. Again, like I heard the gentleman say earlier, I become a person of God. I started taking care of my family, started taking care of my mom and dad. I lost my mom and dad a couple of years ago, but I stayed and took care of them. No matter what I ever fell back into, I always took care of my parents. And I made a vow to them, not a promise, but a vow that I would before they died, that I'd make them proud of me again as they had been before. I was I was an outstanding citizen at when I was younger. I had a good record with the fire department. I was a paramedic and stuff with Chattanooga, and I was better myself. I was going to Emory University to become a PA in orthopedics and cardiology and stuff like that. But I got involved with that crowd, the college crowd, the school crowd, going to the varsities and stuff down there, and I couldn't control drinking. And before I knew it, the drinking escalated into drugs. Because I, just wasn't good enough for me. But never got no major drug charges. The only charge I ever got with drugs, I had some of my own prescribed medication in one of my, in a little bottle in my car, and I was stopped at a roadblock, and they seen the pills there. And since they was not in the labeled bottle, they charged me with that. I've been charged with that. That was the only charge that I've ever had for any type of drug that I can remember. The other thing, it was dismissed or whatever if it came before it. I just, my record was driving. Most of them, if you look at my charges, most of those charges was driving DUI or driving on revoke. That, of course, carries the same penalty. If you get caught driving on revoke, it carries the same penalty as driving DUI. And it escalates, and that's how it escalated to an habitual offender. Because I just couldn't, I had to work, and I had to, that's what I felt like, but I just couldn't, I was an alcoholic. But like I said, over 14 years now, I never not touched a drop. I don't smoke, I don't do anything. I don't take any medication. My heart's fine. The Lord's has blessed me, and, I've changed my life. I've went to different places. I've been able to work at Volkswagen plant. I was quality control manager at Volkswagen for a little over 2 years. I left there because of the problems they were having trying to bring the union in. They're still working on that, and I had the authority to hire and fire temp people, and I just couldn't do it because they were going to let all the temp people go, and it just bothered me the fact that they'd been there working for a year or so, and they put it on my back to fire them. So I left there and I went to work with Secure Automation. I worked at different temp services. To keep busy, keep work, because there was not a lot of jobs available. I came to work with Secure Automation, working door to door. Went through the process of getting hired, and of course, they did the background check through that company, and I was able to work until my alarm things come back. I am the branch manager. I made branch manager within 2 months. I was able to excel in the door-to-door. I know people in Chattanooga, and a lot of people know me. A lot of people respect me because they've seen where I've come from. And I've brought some letters of, recommendation, people that know me, people that I do business with. I've got excellent credit. I've established myself. I feel like, to come from where I've come from, and be able to stand up and testify and tell kids and show people. I do it to everybody I work with, even my employers. I let them know, what you can, what you can do with your life. Because we have people that come through and they'll last maybe a week or two, but, of course the background checks ain't come back. And, I can sort of pick up on what I've got coming in that I work with. But I've never failed to let anybody know, the truth in my life. I've accepted responsibility for everything, that's happened. And all I ask, I love my job. I love people. I love what I do. You know, I know that this goes back 20-something years, but I did stop. I mean, I live a good, clean life, a Christian life. I teach music in church. I teach children that has problems with family, that has, issues at home, that don't have family. I have a music program where I give them guitars. I furnish guitars. I furnish a class for them, to where they can better themselves and overcome their problems, that they have by listening to my problems. And so, basically, that's all I can say, is that I love my job, and this I've made, I'm able to take care of my grandkids. I have 2 grandkids at home. And, since I haven't been able to do the ADT, it's took a toll on me. But I'm still there. I was there hoping that I could, that I could prove myself and maybe get my my board approval to where I could go back to the work. I do run the branch. I still do the branch, but of course I can't participate in the ADTs, and that kills me. I mean, I went from like $4,700 a week to $200 and $300 a week, because we also promote DirecTV, and of course they don't require a thing, but I'm able to work my guys and get my branch pay. That's what I live off of is that now until what happens.
I appreciate that. We're probably 2007 is probably a little more concerning for us. The stuff you talked about before is a little bit older. When something is kind of recent, that's kind of where we kind of focus at.
If that's the case where I was a contractor, is that the one? Where
I've got a charge here of theft, public intoxication.
Public intoxication in 2007.
Yep.
Let me see, 2007.
6 years ago.
I'm trying to think back when that happened. I mean, I don't recall that. I know the charge. I know I was charged with that. I think it was a party that I went to, and I did drink some. I don't think that I didn't drink to an excess of being drunk, I don't think, but we were loud, and I was drinking. But there again, that's a thing. I guess I did drink then. I can't say that I didn't, because I went to a thing with some guys from the Navy. I think that's when that charge was brought on me. But I went ahead and admitted the fact that I was guilty. I did drink at that party, and we went down the street and was going to some different bars, and we got caught for I think it was public drunkenness, public intoxication at that time. But since then, I can honestly, anybody can check me at any kind of drug test, any kind of alcohol. I haven't done that. Didn't know, and I forget things, I guess, but I did. I do recall that since you brought it up. I did put a statement in my answer to those charges when I
You got a theft by conversion.
Yeah, that's I was a contractor. I've got the paperwork on that. It was what NOLO or whatever. They just I had to make restitution. I had a heart attack at that time, and I wasn't able to complete the job. And what happened is she gave me money and material, and I'd asked her to let my crew finish it. And I had done work for Miss Stone before, but I was not in a position where I could finish the job. And she wanted her money and everything back. I'd already bought material and all this stuff. And since she wasn't going to let me finish the job, we just went ahead and used the material on the job. And I went through the court. I have the paperwork.
I saw where
and
they disposed it.
I made restitution and paid it all back.
Okay.
Every penny of it. And they just, it never was actually, before the court, I just had to prove to them that I would pay it.
I think when that happens, and what I can see on my side, I guess, is when you plead guilty on something, I'm gonna ask a question.
I didn't plead
about it.
guilty to that. I just that charge was never brought before the court. It's just that I accepted to pay. They wanted me to pay restitution before it, and make sure that it was before the charges was ever brought to me. I've got where they actually the whole charge in my folder here, where it shows how they where I had to pay it back, the money to the court. I asked them to let me pay them back so that I would have proof that I paid it through the court system. And that was in Catoosa County.
I probably don't have any more questions.
I would like to ask a question if I could. I think I heard you talk about being a branch manager in Chattanooga.
Yes, ma'am.
Is that for SWS?
I work for, we do DirecTV.
Yes, sir. I
It
just
is for-
asked you, was that
Ye-
for,
yes,
is
ma'am,
it
it
for
is.
SWS? SWS doesn't have a location in it. It
Well,
doesn't
it's
have an
it's
office in
actually
Chattanooga.
Secure Automation. I don't
Do
know why.
you
how
hold
that's-
a,
okay.
do you hold a license in Chattanooga?
It's under another division.
It's called the promo team.
It's called, yeah. we call it
It's the promo team.
Where he is doing satellite television.
I can't be involved with the
That's
ADT.
currently where he has been working.
I just know he made the statement he was a branch officer. I thought that's what I heard, and I didn't want it on the record, you know.
Right, and it's what they consider a branch, not.
If I'm not going to question or vote on this, I'm confused. What other business opportunities operates out of this, quote, branch, other than satellite TV, from your statement?
I believe that the only, he does,
Ish.
he has set up a company to do,
Yeah, if you look at the things, Lonnie Garner is the team leader on the ADT. He took my position when I couldn't get my license. So he has actually took over the ADT part of it. I'm not involved with it. I can't write any contracts. I can't have any say on any of the sales or anything. They made that point blank clear when I remained there and worked in the direct aspect of it.
so, you know, once we got the notification.
You look at any of the
Wait a minute, Mr. Bish, why don't you step forward to the microphone so we'll have a record of what you're saying, and maybe you can help us to better understand.
The owner of the company, Matt Thompson, has set up a couple of different companies. The main one was, which we went through, Secure Watch, Secure Automation. So it's actually, I guess its legal name is SWS LLC DBA Secure Automation. He has set up a couple of other DBAs to do satellite. One that does the DirecTV satellite and one that does the Dish satellite. So when we got notification on Mr. Goins, it was made clear that he in no way could touch anything that had to do with Secure Automation. As long as he was just doing the work for the DirecTV and Dish, then that did not fall under anything that was regulated by the alarm board. And so even though he still maintained being over, management-wise, being over that what we internally call a branch, but then we felt that he was doing what was appropriate as far as not being in violation of the alarm board here, involved in any of the day-to-day operation with any of the information or anything else that had to do with the alarm board.
So he doesn't have access to alarm files.
No files are kept at any of the offices that Matt has set up. The contracts are forwarded every day via I want to say FedEx, but it's not FedEx. We use UPS. So all contracts are forwarded to our corporate every single day. They come straight from the field through the team lead and then to the corporate office. So in the field, we have no contracts or any information concerning any customer.
Where is the corporate office? Is it
It is in Knoxville.
in Knoxville?
It's in Knoxville, now on Schubert Road.
Okay, so there's an entity in Knoxville, and is that SWS or?
It's, that's where the SWS is, and also then the, everything that manages all the different, we use the same HR portion, whether we're hiring and firing for people for secure automation or the other divisions that has. So all of that is housed in Knoxville.
So if I understand it, and this is, obviously we've had no contact with this before. If I would understand it, then you've got a licensed entity in Knoxville by some name.
Yes, it's, I believe the official name for Tennessee is SWS LLC, DBA Secure Automation LLC, because now you have to, most of the states now require that in your DBA, you put what the parent company is. So we also now have to put LLC behind the
So
Secure Automation.
you've got a licensed entity in Knoxville with a qualified agent,
Correct, that's me.
and you've got a branch of some sort in.
We have a company branch, but not a branch that, on the,
They don't have a branch
Branch.
office in Chattanooga. Office, and that's for us now, I'm talking
Right.
about, is Knoxville.
You don't do security work at all in Chattanooga.
they do, but none of the facilities are open to the public. Everything that they do on the security side is in the door-to-door. So the only thing that
It's a
they
training facility.
is training, and it's where we remote some equipment, but there is no selling from the premise itself. There's no phone service in there. All that is used for is for the salespeople to meet and get their marching orders for the day, and then they go out.
ADT is on one side and Direct Dish is on the opposite side. I'm not allowed to actually train or talk to anybody about ADT. That's what I was told. So that's why I was saying I went from an astronomical payday to what I'm doing now in hopes to get my license. That's where I could take over and go back into ADT, you know.
I guess I'm just not real clear. It certainly sounds like you've got a branch operation in Chattanooga where you're having salesmen come in and they're going out and selling from that
But what they
position.
do, we don't sell. Actually, we set up appointments, and they do appointments. They promote it. They tell them what they've got, and then they will actually give the system to them for the monitoring fee, and for there's nothing sold. We just tell them the program, tell them what we can do for them. It's not like having a sales department going out and selling, but like
But you actually are, even though you're giving
well,
them
you
the
are, but I
system.
mean,
Yeah,
we're
just
not
like you are.
classified as
You,
salesmen. I mean, to me, it's a promotion.
it's kind of like a call center's not a monitoring.
Didn't we
center.
have a letter sent to us from somebody who had a training center 2 meetings ago? One side was for training, the other side was for parts that were sitting there for alarms, but no, it was just a training center, not a It's installation and install service. This sounds like, if I recollect from 2 meetings ago, that was something that was presented. Somebody sent a letter saying that that's what they were using it for. Okay, we'll go back to what we're doing.
I guess it's really a different question. Sounds to me like you got a branch in Chattanooga, but there may be some technicality there that I don't fully comprehend at this point. Sounds like you're sending out salespeople from a branch office, but staff, do I incorrectly understand that? Josh?
I think in the past, if it's not open to the public, the board has not required licensure under the branch office definition.
I think it's
It sounds like
been-
it's is it like a warehouse location where people get work orders
Yeah, we
from?
have, it's labeled on the door that this is not open to the public.
Yeah.
That there can, nobody from the public
It's,
can enter the building.
it's,
I
most
know
of
we've
the
had
offices are in
instance where
a,
we had, where the installers could go pick up equipment, but I don't think we've ever had the situation where you had a sales staff operating out of that office. I think that's what distinguishes it from
Yeah,
previous
it's-
complaints, is you have a full sales force, whether they're giving the unit or leasing it or whatever, they are actually selling units out of that premises.
Well, maybe that's a separate issue.
That's
I
true.
think the issue we have here
Just whether or not
at
to
at
approve
hand is
Mr.
Mr. Goins' application. Mr. Bish, you have any comments that would help the board to make a reasonable decision on this issue?
I've been Secure Watch's QA now for about going on 4 years or so. I will say that this is the first time I've appeared before you where I've been willing to allow an individual to make the presentation. Most times when I look at what they write and things, I've never been willing to come before and allow this to happen. I think the one thing that turned me when I read through everything that went on, and I keyed in on the thing that happened in 07-2 being so close. But I guess there's two things that I look at. One is I looked at what's going on at the national level with Congress putting down guidance to state agencies, trying to make sure that we're not holding something against an individual for an inordinate amount of time. Because there are a lot of states that it doesn't matter if you did something 50 years ago and you're done in that state. The other is the reference letter that came from law enforcement. When I read that had a lot of sway with me to sit there and say, yeah, I should be willing to allow at least Mr. Goins to make his case and presentation. Had that letter not been in there, I still would have struggled. But I would say that letter coming from law enforcement saying that they felt that he had cleaned up and deserved another chance is what swayed me.
Which letter from law enforcement are you referring to?
Is that in our record here?
I don't believe I have that.
I didn't see
I
it
don't,
either.
I haven't gotten any kind of letter from law enforcement.
I read it. All my copies that I had, I sent Allison my copies to those, she had it up there.
Well, she sent me, I've got one from Lonnie Gardner. I printed them all out. Bill Scoggins. Somebody named Chris.
He's the president of a dealership, car dealership.
Chris Pendergrass. And Daniel A. Bradley. And a letter from Mr. Bish.
I didn't see anything that I identified as a law enforcement agency, which is the reason
That
I-
has somehow that missed being sent forth. And I did not print my whole copy out.
Well, who was it from? You remember?
It was from a couple of guys that I had worked with
got the attachments. I'm trying to pull up.
No, we don't have them. I
I
went back
didn't.
through.
It's not
I
in there. I
didn't
was
see
looking to
that,
see if
yeah.
I got it in the email where you sent me all that. I'm just trying to check if I can get my computer back, right?
Well, in answer to your question or your comment there a minute ago, Mr. Bish, we consider any offense where there's been an arrest and a record. We try and consider each case individually. There not any, and that's the reason we're here. There's not any particular instance where someone has had an offense in the distant past where they're automatically disqualified. We try and consider each case on its own merits. We try and consider the good moral character, which is the term that's used in the statute, of each individual, and try and ascertain that as best we can. And you've provided some valuable evidence towards that. And then it becomes incumbent upon the board to make a decision whether or not we feel that Mr. Goins here is someone that is of good moral character and therefore would be eligible and appropriate in the alarm industry.
I appreciate
And in this case, it's a difficult decision.
it is, and I can appreciate that because it was a difficult decision for myself. But I felt that it needed to at least be given the opportunity for this board to make that decision instead of me making it like I normally do.
That's the responsibility of this board, is to make difficult decisions like that. What do you think,
I don't have anything else.
Keith? The way the situation stands at this point is Mr. Goins' application was denied. And he's asking us to reconsider that.
If I could, I'd also like to make one other. It was not denied for which I see a lot of times where individuals are not forthcoming with everything that they have in their past. So I think that the fact that was another thing that I took into consideration in my decision, was that it did not involve anything wise, which meant that he was forthcoming with everything straight up front.
He had some disclosure. I'd agree with that.
It's a heavy decision. It's not one
Yeah.
to be taken lightly, and everyone on this board is very serious about what we do. For me, it's not one of the cut and dry decisions that I so often do get to see, but I think with everything that I've heard here today and taking you to be honest in what you're saying, I wouldn't have a problem approving the application.
I'll second, but you're gonna be responsible for him, George.
Yes. If I could, if it would help any, if we could, we would make sure that those letters from the law enforcement were made part of his record with the board also. We could make sure that those were part.
I just sent Allison an email and asked her to send them, so.
So I'll make that motion.
I'll second.
I apologize, and I just don't know, and I might have missed it, but was there any explanation given about this crack cocaine possession charge? I understand you had a charge for prescription medication that there was an issue there, but I'm not sure that I ever heard an explanation about the crack cocaine position.
I made a comment a while ago that it escalated into drugs. That I had, at that time, that I had overcome all this stuff, that I went through drug counseling. I got my drug counseling certificates where I went through everything to get completed. Off that, I have them in my folder. I mean, like I said a while ago, I mean, I'm not denying what I done. You know, I know what I had done. I did escalate. That's what I was saying a while ago, that I went in, I escalated on up through the other things. But I have cleaned up. I'm willing to take a drug test anytime, any place, because I just don't do that. I mean, I made a vow to my family that I would see them one day, you know, and that's what I intend to do. And I'm raising grandkids. And like I said, I've got 2 grandkids at home, grandsons, and you know, I want to make an example of all kids and all people that, you know, just because that you went down that road don't mean you have to stay down that road. I have many people that know me from the past as a drug addict or an alcoholic that have actually, I've touched their lives and got them back into church and got them back into the workforce and been able to be a citizen again. Is it easy? No, it's not easy. It's not easy, but it's something that I'm willing to do. I will do it for the rest of my life here. I mean, you know, I'm dedicated to that, and I know what kind of mistakes I made. But I ask, you know, I mean, I just ask for forgiveness of, you know, and let me continue to be able to support my family, and I don't have a lot of things to fall back on anymore, you know, I mean, I've got things I can do, but as far as construction stuff, I'm not at the age where I can go out there and build a house or remodel a house and stuff now. But I am able to talk to people, and I'm able to correspond with people, and I never hide a fact, like I said, from my people that come into me, into my branches or into my whatever we want to call it when we talk about ourselves. I let it be known everywhere I go. My past, so that some people can see, hey, you know, I wear a lot of scars from that mentally, you know. I mean, I carry that, but I've been forgiven, so, you know, I can't sway you either way, other than what, you know, as far as my word that I can give you, that I'm going to be there for my job. I've never missed a day of work. I was bit by a copperhead 3 weeks ago. I've never missed a day of work. I've never missed a minute of work. I've always been there 2-3 hours early to make sure that I was able to do what I was supposed to do.
Mr. Tucker.
Question, I guess I might ask, how much interaction, George, do you have with Mr. Bish? Are you in Knoxville or Chattanooga? You're in Knoxville.
When I come into Tennessee, I'm in Knoxville, yes.
He's in Chattanooga.
He's in Chattanooga,
So
yes.
who's going to be responsible for the branch down there in Chattanooga?
A lot of that will depend on what happens here today, what it ends up with.
If I get to get my license, I get to go back into the ADT aspect of it. Otherwise, you know, with what I'm doing with DirecTV, I've been just holding on to the fact that maybe, you know, I had to represent my case. For me, that's why I wanted to be here, so that I could actually, you know, speak. Everything in my power to help them and teach them, you know. A lot of them have issues. I've got letters here from guys that had issues at work that we've been able to sit down and I treat them like my own kids. You know, I buy them clothes, I feed them, I've got to pay their bills. You know, I give them a lot of advice about their drinking and about stuff like that, where it's going to lead you. I didn't start it till later on in my life. See, I didn't start that until later on. And like I said, I had a tragedy that just blew me apart. And I lost it. And
I think
We
we
gonna
got
stick
all
on
that
the
part
motion.
pretty good.
yeah, I mean, that's all I'm saying.
We-
Yeah. But if I'm able to go back to work with ADT, then I will take over my branch again. I say branch, facility. It's actually it's a facility for training and for equipment. But we do meet there, and that's what we do. And we go out into the field.
Anytime you present something that's selling,
Well, that
okay, I know it.
that would seem to be another issue.
That, but you're going to be responsible for something. That's why I just brought that back to
Yes, sir.
Mr. Bishop.
Yes, sir.
Somebody, I think it needs to be monitored. That's just coming from me.
What I have to answer to is HR, and we have conference calls, routinely, so that they'll know what's going on. And of course, like he said, all of the stuff, I'm not involved with ADT right now, so I can't make a call on. But I do know that their side, they do what they do, and I stay out of it.
Madam Chairman, I believe we've got a motion and a second on the
Right.
floor.
Right.
I would believe it appropriate to go ahead and vote on that.
We have a motion.
Aye.
All opposed?
No,
Mr. Tucker?
I said aye.
You did say aye?
Mm-hmm.
Okay, by a vote of 2 to 1. So sorry. By a vote of 2 to 1 with Mr. Tucker and Mr. Harvey voting yes, you are given your employee registration. Thank you.
if I may, Madam Chairman, I think we really need to reconsider the branch office
Right.
type arrangement that as it would appear, we really don't have enough information to make a good decision on that at this point. I think that needs to be reconsidered or investigated. Let's put it that way. I don't know that
I think we
it
need
need.
a motion to have an investigation done on that.
Okay, I don't think it needs to rise to the level of a complaint at this point, but I think because apparently it's been something, it's been an ongoing process. I'd make a motion that we revisit and investigate the branch office arrangement that has been presented to us with this company, and it be reconsidered. There may also, Josh, be some other cases of a similar nature where you would have an apparent branch office that needs to be considered as well. So I think we should investigate that and clarify that, and so I'd put that in the form of a motion.
Okay,
I'll second.
We have a motion and a second to authorize our legal representative to conduct an investigation into whether or not these are branches that require licensing. All in favor, voice by saying aye.
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 All opposed? The motion carries. Okay, thank you.
Doing? And I do apologize, it's taken us so long. Okay.
I think K is a Mr. Raymond.
Dewey Raymond, is
he
Mr. Raymond
present?
here? Have you signed in yet, Mr. Raymond? All right, we'll let them take, if you would just have a seat here for this front row. It is K, and you can start, if you would, on page 19, on his application, he lists his, what he just says, see attached.
Mr. Raymond brought these letters of recommendation of.
Raymond's letters of.
I'm sorry, yeah.
And it was page 19 and 20, you'll see a type description 2021-22 of charges.
Number K.
Might help you to just go straight to that.
Not letter. It's
Most of this, these are not the same document. The judge, I guess the judge did sign them, but they're not dated. So now they've been expunged, or they're in the process of being expunged?
said that when I received those in the mail, that means that they are off my record.
Okay. You don't have any other letters, these are just,
Where all my child support and everything's up to date.
okay. So some of the charges have been expunged since you submitted the act.
Oh, shit.
All the expungement, you are talking about Tennessee.
Yes, ma'am.
trying to figure out what expungement goes with what charge. Because it's still gonna be on the record. If they're just August, I didn't know he had the expungements, therefore I didn't run the background check.
He just brought those in, so.
Would you like to make copies so that y'all have them too as well?
I think all you need to copy is the actual
The
expungement order.
expungement order.
The three, there's
And
three
we can
of
still
them.
be talking with you, sir, and let them look at the record while we're doing that.
Yeah, I was looking at,
Go
no,
ahead.
no, I was trying to get her, but that's all right, go ahead.
Mr. Ledford here also? Okay. Did you sign in also? Thank you.
I just realized it. Okay, this was for kidnapping on 07. See, these weren't convictions. They were all nolly pros, so they weren't convictions anyway.
Wait a second, is that?
That's to expunge his record from.
Kidnapping, robbery.
Well, they were already.
They were
nolly
already
pros on the
nolly
report.
pros, so
On
they're
the
not
report.
considered convictions anyway, but now they've been expunged like they never happened.
Right, they won't be on the record next time I run it.
So
How
the
many of
three
these-
things that were expunged were the three charges that show up on his report that showed they weren't prosecuted.
Make sure I understand our situation here. Mr. Raymond was invited in for an informal conference to discuss, to better understand this, or we denied him previously. What?
Actually, we
He's an
told.
appeal.
He's not,
Isn't he appeal?
no, we told his
Oh.
employer that his file would be presented to the board today, and they requested to be here.
Okay, so he has not been
Denied.
denied. This is an
He
initial
was denied for a
consideration.
material misstatement in June. He
Okay.
reapplied,
Okay, so
but
you
he's
got a
not
material
appealing
misstatement.
anything. We
It's a
told him his
reapply.
file had to be presented, and they asked to be here.
I understand. I understand now.
I have a, Mr. Raymond, we have a package here that packets with some of them pretty sizable penalties, I guess, or these are fines that you're paying off?
It's my child support, my three
Are
different
these-
child support cases, and I was told I needed to show that I had been paying, I was current. I do have arrearages, but she went back, the lady with the child support went back to January to show that I am making my child support payments and stuff like I'm supposed to.
Aware if you get behind again, they'll send us the notice, and if you are approved, it'll be suspended.
We had copies of them.
Mr. Raymond, that's quite a record you have here. Most of the ones we see don't involve as much paper as you have
Yes, sir.
brought to our attention.
Well, with those, a lot of them, if you go back, I wrote some bad checks to a few stores. I didn't have the money in the bank to cover them, and I was arrested on them. And I was put on probation and stuff, and in like DeKalb County and in Wilson County and even Cannon County, their court cost fees and stuff are pretty sizable. And I wasn't able to complete to get everything paid off and stuff, so therefore they put you into a violation and they show all your original charges back again, and those charges, a lot of them, the check violation and the failure to appear and that type of thing, is just the very first initial charge, but it took me until 4 years ago to finally get some of the stuff that was in 2005 and 2006 paid off. But a lot of it is, if you actually pull the police report or the court documents, you can see that it was over some of the same checks. It just kept on just kind of cycling itself.
What was the situation concerning now this was Noel Prost, the kidnapping and attempted kidnapping with bodily risk, and could you provide a little bit of background information on that particular situation?
Yes, sir. That was kind of a complete misunderstanding. It was someone thought that a way to kind of get even with me and kind of cause me a lot of problems was to make up lies and kind of, try to have me arrested and that kind of thing. And then when the police actually, the DA and stuff looked at it and everything, they could tell that it was just completely outrageous. And they told me, they said, no, that
they're not going to prosecute.
Yeah, they
it
said
then.
they completely believed everything that I told them, because it was facts. So
I'm sorry, from a legal standpoint, I just want to make sure that we have on the record that we're not considering charges that are nollie prost or expunged for.
Was that one expunged?
Yes.
Those
Oh,
are the
okay,
new
thank you.
ones, so
Thank you.
we really shouldn't be even.
Let me make sure,
considering-
this one from Wilson County back in 2006, it's not been expunged. The one, failure to appear, probation violation, and a Schedule II drug violation, that one wasn't expunged, was it?
no, ma'am. The Schedule 2
Yeah.
should not be on there, because what had happened is the violation of probation, therefore defers back to the check violation that I had, the bad check, and they put me on probation, and where I didn't meet requirements I didn't do my probation like I was supposed to, have my money paid. They put me into a violation, and when they picked me up, the officer said that I had drugs in my possession, and it was an actual officer that I went to school with, and we went in front of Judge Tatum in Lebanon, and the officer told him that he was under the impression that I could have had drugs on me, but Judge Tatum asked him, did you catch him with any drugs? Was there any drugs or anything at all sent to the lab or anything? And there was no drugs to be provided. There was no drugs found. That was just, so Judge Tatum completely dismissed it and sent the other charges on up to the other court.
You're telling this board that you were arrested for possession of a Schedule II drug, which is a specific list of drugs, and you had nothing on you?
No, ma'am.
Okay, thank you.
And they also took me to the emergency room, and because the officer tried to say that I ate it or whatever, that he thought that I disposed of some type of drug by eating it, and took me to the emergency room, and they drug tested me and everything, and there was nothing, no Schedule II in my system.
And you have looks like a domestic violence assault charge also in the last few years. Is that still a conviction, or what is the status on that?
Last few years. back in 2001.
Yeah, domestic violence,
Okay, that,
domestic assault. What was the disposition on that?
anger management classes.
Was
There
it
was-
disposed of after you completed the anger management, or
Yeah.
do you have a conviction for it?
It was a pretrial diversion,
Okay,
and there was nobody injured or anything. It was just an argument.
thank you. When was the last time you were arrested for actually a bad check violation, not some type of failure to pay your court cost or whatever?
I believe it was in 2000 and 2007, 2008 at Three Forks Marketplace. I remember the place, but I can't remember exactly what year it was.
I think I have one here for January of 2008.
That sounds about right.
Okay.
All of this, everything that you are sitting here looking at is all the checks have been paid. DeKalb County, Cannon County, Wilson County, everything is been paid in full. Everything is done. There is nothing else out there at all besides the child support that is deducted from my check weekly. I know sitting and looking at that, when I got the TV,
Hold on a second. I'm moving up to 2011, and I've got an evading arrest, driving on revoked, attachment order, resisting arrest, and evading arrest. I'm not sure, some sheriff's department, let's see, but here's a 2011. What's the details for that? Possibly something to do with Lebanon, Tennessee?
it was Watertown, Tennessee.
Oh, Watertown. What was the deal with that?
Watertown is a very, very small town.
Mm-hmm.
And I had a child support attachment on me from when I was behind on my child support. And the officer, the 2006 charge, I had a reckless endangerment 2006 in Watertown. Okay, and ever since then, it's, if they know you, then they'll talk to you and this and that, and they seen me and knew that I had a attachment order, and I was about a mile from my house, and instead of pulling over and letting him impound my vehicle and all that, I didn't go at a high rate of speed. I went to my house, parked, got out, went to jail for child support attachment. And
Why would he have impounded your car?
because I had a child support warrant, and that's gonna take me to jail.
Why would they have impounded your car?
Because if I'd have stopped right where he, cut the emergency flashers on, if I'd have pulled over right there, then when he got me out of the car and stuff and knew that I had a warrant, he'd have put me straight in the back of his car. And then I didn't have any license also at that time.
That's probably why. Okay. Y'all have questions for him? So you're saying in 2011, you weren't arrested again for evading arrest or driving over revoked or resisting or another charge of evading. You're saying these 2011 arrests are tied back into something from 2006?
No, he did charge me with evading arrest because I did not stop.
But I'm asking you, were you arrested on March the 29th, 2011 for evading arrest, driving on revoked, resisting arrest, and evading arrest?
Yes, ma'am.
So you were arrested in 2006 in Watertown and in 2011, is that correct? Okay. Now, on this Nashville Metro from 3/13 of 2013, you were arrested for failure to appear. Now, is that tied into your child support, or is that involving some other unrelated charge?
I got a citation in 2005 to go be booked, and I didn't go get booked, and they charged me, and I had been, arrested in between them times, and it had fell through the cracks, and I got pulled over on that day, and all these years, it was just fell through the cracks. And when I got pulled over that day, I got arrested. I made bond. I went to court in April, and the judge and the DA asked me if I had my driver's license, and I said yes. They said, "Well, do you understand this charge is, almost 10 years old?" And I said, "Yes, ma'am." And they asked to see my driver's license. I showed them my driver's license, and she said, "Okay, you're done." I said, "Well, this has been so long, I don't want this to come up again and something happened. Do I got any kind of fines or anything like this to pay?" And she said, "No, you're completely done. It's been too long. You got your license." And she typed in my driver's license number on the computer also, and she sent me on my way.
Why were you stopped to begin with if they found this outstanding warrant on you? Were you violating some traffic law back in March for them to pull you over?
No, ma'am. I was pulled over by an officer coming down Donaldson Pike. I have an older car that I've been working on that is fixed up pretty nicely, and when the officer seen the vehicle, the officer pulled me over and said that the vehicle would be a type of vehicle that might possibly be, have something illegal or something in it.
You have any questions for Mr. Reed? Or Mr. Raymond, I'm sorry. Mr. Raymond.
Do you have is this Mr. Ledford?
Yes,
Would Mr. Ledford like to make a statement as well? It would help us make a decision in this matter.
I'm Jeff Ledford. I'm not only the DQA at System Integrations, but also the president and one of the owners of the company. Typically, when something like this comes through with our employees, as a business owner, it's hard to find somebody you believe in that's trustworthy, that follows all the model employee since he come to work for us in April. After looking through, so I spent some time to try to go through this record with him, and Jerry spent hours trying to make some sense of it. It's very lengthy and very confusing. After we compiled all that, we asked Tony to tell us the story, tell us really what's going on here, because this doesn't make any sense. And he hasn't told the story today. He hasn't told why, what's happened with the child support, why some of these things tripled when he was incarcerated, how some of the things got behind because he's stuck, and the way he was treated unfairly from the child support standpoint. They were taking over $400 a week out of a check of a man that wasn't making enough money to make those types of payments, and things that just started to, that if I was in the same position, I'm not sure I wouldn't end up in the same place. And so that's why I wanted to be here with him today. I believe him as an employee and as a person, so I wanted him to have an opportunity to try to explain some of those things. I think he's trying to answer because of the confusion of all the things that's going on there, and you're not getting the real story behind maybe where he came from and why he got where he was at. So if you can spare a few more minutes, I'd like for him to maybe tell some of those stories so you can get a better understanding. The charges are confusing because they kind of overlap and they get on top of each other sometimes because of the mistakes he made. Personal life is a lot different than it was at the time all this was going on. And I think he probably should explain some of that to you and where he's at now versus some of the immature, bad decisions he's made in his past. That's where I'm coming from, and if we're lucky enough for you to approve his application, I feel like he'll be a career employee for us.
I would be happy to hear if there's more to the story than just answering questions. So yeah, maybe a further explanation would be appropriate.
I know looking at my background, I went to several jobs, and those gonna turn out to be good jobs, and they look at my background, and it always, kind of throws up a red flag, and I'm kind of shot out the door, and I have some pretty bad child support issues, and I wasn't able to make it to a court date in 2006 on my child support, and that's when my wife and I was going to divorce, and I was actually incarcerated is why I didn't make it to the court date, because my wife that I was going to divorce on at the time was dating a young man that was physically abusing my son, and I went and tried to go through the proper channels with Children's Services, with the Watertown Police Department, and this type of thing. Well, I was getting my son every other weekend at the time. Well, the next time I got my son, he had fresh marks on him. So I kind of took it upon myself. I took my son to my mother's, and I went out to my ex-wife's house and her boyfriends and had a physical confrontation with them. And that's how all the stuff in Watertown got kind of stirred up. But anyway, when I went to court, they gave me some jail time, and I was sitting in jail. So they have child support court without me, and the rest of the divorce and stuff, they just bringing me stuff over there to sign it, and this and that, and they set my child support at $411 a week, and I'm incarcerated. So the whole time I'm incarcerated, as you see, that $48,000, you're seeing that backed up on me for 15 months. Got out, I had probations to pay, I couldn't make it. And so, to be honest with you, I got a career going right now. I'm trying to. And I'm married now, I got 2 kids, and I can't keep employment. I can't keep anything else because stuff like this just continues to happen to me every time. And it gets hard because I've not been in trouble in a while. My wife is a supervisor at performance food groups, and I sit here and I pay, being in and out of jail because of child support. And then I found a judge that finally gave me a chance to do something with my life, and when everything starts coming together for me, it's like when I go 3 steps up, I get knocked back 4 steps. So I mean, and then like here today, if I don't get this license, I lose my job, then I get one payment behind on my child support, I'm going straight back to jail again. So this is how these charges that keep going back on me and going back on me, this is the continuation that I've had to deal with. And
So as of right now, the only thing that you're still involved with the court with is your back child support payment, and you're current on that. You don't have any more fines for criminal offenses, nothing else in the closet that, other than just your back child support, correct?
nothing, me and my wife, we ain't got a loan, and we paid off every single thing on. I've got my driver's license back. I've got everything I'm supposed to have. I got a job. I got a nice home. But it's just, and then it's like everybody looks at my background and they judge somebody that I'm not, just because I wrote bad checks. And I took up for my son, a man putting his hands on my son. And this is, this, because I know when y'all first looked at that background check, I know what went through y'all's heads. The same thing goes through everybody else's. But you got to know me. It's like when I told them, though I wanted to come up here. I mean, I sit here and look like an idiot right now, but when you sit here and have to go through what I've been through in my life, you'd completely understand.
Well, first of all, you don't look like an idiot, and second of all, I'm not speaking for the board, but I'm speaking as an individual. In my opinion, you cared enough about pursuing this job that you made a personal appearance, which, the board can tell you we don't always see people that impassioned about a job. So, you can take calling yourself an idiot. I don't want to hear that because you're not an idiot.
The only good thing that's happened to me is in December 19th, the same now, I'm $48,000 behind on child support. My son that was getting beat on, he's mentally challenged, and my ex-wife signed him over, went and surrendered him to the state. So he was in foster care for 18 months.
DCS came and found me. I went through parenting classes. I went through youth villages. I went through everything. And finally, on December the 19th, I got custody of my son through the state. The state granted me custody. Well, after that, now my son is at Laurel Heights Hospital in Atlanta, Georgia, because he's got some severe mental problems that they're trying to get worked out where, but you know, the DCS workers even told me then that they said and looked at my background and looked at what I've been through, and they said, and they told me, she said, I feel sorry for you. She said, because people give stories all the time to try to get this and get this out of life, but dude, I'm not telling no story. I'm not asking for nothing. I just want to work. I work every day. I'm on time every day. I missed 3 days since I've been with that company. 1 day because I had to go pick up my grandmother. I'm sorry. I had to go take my son to Atlanta, Georgia when he got admitted to the hospital. Then I missed 2 days when my grandmother passed away. And they actually gave me 3 days to be off with my grandmother. But I came back on 2 days after the day she was buried. Every night when I get off work, I go home and take my 7-year-old son to this football practice. My daughter, she's taking choir. She's got a choir concert tonight. So you don't understand how it makes a man feel when just because of the idiot things that I've done in my past, by writing checks and taking up for my son and driving on a license or missing a court date. Whatever decision y'all make, I know if I don't get my license, I'm going to lose this job. And I might have bit off more than I choose with the house and stuff that I live in, but me and my wife, we want to actually have something nice. I ain't never had nothing nice because I've been in jail, in and out of jail and stuff because of child support. So, I don't know where my life is supposed to start and where my life is supposed to end. I'm 31 years old, and I actually am for once doing better than I ever have. And then, now you know what it's at. I don't know.
Madam Chairman, I make a motion that we grant Mr. Raymond's application.
We have a motion by Mr. Roberts, a second by the other two board members simultaneously to grant Mr. Raymond his registered employee application. All in favor, voice by saying aye. Aye. All opposed? Congratulations.
Thank you.
And don't disappoint.
I'd also like to point out that Mr. Ledford's comments carried considerable weight, in my opinion.
Absolutely.
Seems like you've got an employer there that really cares for you, cares about you, and enough to go into depth in your particular situation. Hope you appreciate that and don't let him down.
That's one reason why I'm kind of feel the way I do right now, because I know that they went out and gave me a job and a lot of people wouldn't, and that's why I do what I do. I give them all I can, and they know my personal kind of thing with my son and stuff right now, and they, if any need I need, they've been there. That's why it's kind of gonna suck if I lost this job, because it's.
Well, thank you both for making the appearance, and again,
It'll take a couple of days.
congratulations.
to get it issued.
Okay, folks, we've got, I believe, one qualifying agent application to review.
Yes, that's Mr. David Rackley.
Oh, ma'am, yes, that's correct, that's
right.
correct, yes.
He's an experience and
He's the
education
expert.
review. He's not a criminal history.
Yeah,
Oh,
we're
that's
finished.
correct, it's just the application review.
Oh, okay. Bachelor of Science, and he's in computer science.
Computer engineering and You remember they used to have licenses and QAs.
Oh, excuse me.
Nobody describes a divorce as good.
If you got a letter from the wife, she'd probably say greedy husband unwilling to
Pay me my part of the
to
business.
share part of the marital assets.
They're talking about how generous I was. They're due.
And
Let me make sure.
His degree in computer science.
Let me make sure I understand the question here.
He's in computer science, bachelor of science. We wanted you to look at his experience and see if it qualified him.
He is applying only for closed circuit television.
At this time. I guess the biggest issue is he admitted in here that he hadn't been licensed to do this work, so we need to address that too. But he does have the degree in computer engineering, which is now acceptable, and he only had to come up with 2 years of experience. Well, I'd say it was predominantly done in Alabama. Not all of it was done in Alabama. And I told him he might end up being assessed a penalty and having to pay a fine before we could issue his license just because of this, but the only way I know to get him qualified is for you guys to look at it.
Well, go ahead and proceed with it. Madam Chairman, I make a motion that we acknowledge that Mr. Rackley has sufficient experience in closed circuit television industry to be granted a license.
I'll second.
Okay,
Proving the degree and the experience.
Yes.
Right.
Yes, I would.
we have a motion by
For closed circuit television.
Mr. Roberts and a second by Mr. Tucker to grant Mr. Rackley his request for licensing as a QA and CCTV only. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, the next thing on, did you address the unlicensed
That's what I
activity
was.
or?
No,
was
no,
that
I
another
did
time?
not.
Do we need to open a complaint for
Asking
investigation?
you.
Yes. Does we have a motion from the board to or not to open this complaint?
I think it should be investigated. I make a motion that we investigate this to determine whether or not he has been engaged in unlicensed activity inappropriately. I think one of the things that need to be done as a part of that is to explain to Mr. Rackley that closed circuit television installation includes both IP cameras and analog cameras as well. He seems to be of the impression that there's a distinction between the two, and in reality, the statute does not make any such distinction.
Okay, we have a motion by Mr. Roberts to authorize a complaint and a second by Mr. Tucker to authorize an investigation and open a complaint into previous possible unlicensed activity by Mr. Rackley. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. Thank you.
All right, we'll go
Now,
to
to the M
the
file.
end. I tried to make, y'all want to take a 5-minute break?
That would be nice. We're gonna take a 10-minute break.
Get a soda in the snack bar or something else.
Okay, we're back on the record again, and we're going to move to the alarm employee application review section. And the first one is Exhibit M, Justin Ray Bing.
Yes, if you take a moment there and, on mine, it's page 7, I believe is what it is. It just tells you what his offense is on his application, and he has behind it a nice little type description of the charges, and then there's the court papers behind you.
Oh, well, I got to that one yet. Is that what it is?
Excuse me. Good grief, he was doing 95.
for a DWI, and it says on his FBI he went to the Shelby County Correction Center. He says he-
Do I understand this to be a DUI charge, domestic assault charge, and a failure to appear charge?
Yes, that's what he's got on there.
But in
He
the
does-
failure to appear, doesn't it tie back into the DUI or
I
something?
think
That's
it-
the way we looked at, because he did.
No,
like
no,
10
it's
months.
a separate incident.
I know, but the failure to appear goes
Yeah.
back to this. It's not a speeding ticket if you look at the subsequent documents related to the DUI. It's that he failed to take care of something to do with that, and there was a
Oh.
warrant out on him. That's what that warrant was for, not just speeding, I don't believe.
It's not the way it would appear.
No, you have to scroll on over and look at
Yeah.
the actual document.
The domestic assault was expunged.
Here it is, right here.
Yeah, but all this happened afterwards, or during the time he was issued.
I know you can cut that off.
Yeah, I
Anyway.
meant to look him up. Let
See,
me
a
look him
warrant
up.
for
I meant to yesterday.
He was placed in custody for the
Active either.
Madam Chairman, after looking at this, and I outlined what I understand the offenses to be, I would make a motion that we grant this application.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to grant Mr. Bing his registered employee application. All in favor, voice by saying aye. Aye. All opposed? Motion carries. The next one, Mr. Harvey.
All right, we'll go to N if you're ready. Eric Wayne Cavanis, that's how I pronounced it. Go straight over to, I believe, page 11. And it's- applicants today have been nice enough to type up all their rest. And it goes straight to the person's criminal history that he's typed up. Several pages, and he has the documents with it.
Questions about this applicant?
It indicates here that he has submitted some sort of a document saying that all of his child support is current. Is that correct? Is there one of the documents that indicates that?
No, I do not have any document that says his child support's current. What will happen if he is not current on his child support and we issue this license, the next time the suspensions come out?
But I can't hear.
I said, what I said was, if he's not current on his child support, once we issue him a license, I get the suspensions, every several months for child support. Since he would hold a license, they would find that out by looking on our database, and they were suspended if he's not current. Yeah, they're sending me notification that he has been suspended, to suspend him due to lack of child support.
So we don't have any way at this moment to verify
I don't
that?
have a way to check them.
Madam Chairman, I make a motion that we grant this application.
To grant his employee registration?
Yes, grant his employee registration.
We have a motion by Mr. Roberts, a second, I think, Mr. Tucker, did you second? To grant this employee registration. All in favor, voice by saying aye.
Aye.
All opposed? I oppose it. The motion carries. 3-1. The men said yes, and I said no. Exhibit O.
Okay, Exhibit O, that applicant is one of my employees, therefore I can not be involved in the discussion. If there are any questions that the board would like to ask, I think I could appropriately answer those, but
I will have a question
I
for you shortly.
would not vote on that.
You can turn to page 6. This is a smaller record. Page 6 is part of the application sheet. Then, excuse me. She does have a typed written explanation there. There are court documents that are attached.
Oh, yeah, let's, I need to,
I'd make a motion that we would accept this employee registration, and I cannot pronounce that last name.
I just called her Miss Cook.
how do you pronounce her last name?
Candace?
That's not her last name, that's her first name. What's her last
He
name?
doesn't go to her last name, is what he's saying.
Just call her Candace.
Telia? Telia?
Yeah.
Okay, we have a motion by Mr. Harvey and a second by Mr. Tucker to grant this Candace Cook Telia's registered employee application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. And that was a 3-0 vote. Beth? 3-0, did you get that? 3-0 vote, he recused himself and it
I
was.
wrote down that yeah.
Got
I
it.
got it. That's why I was looking at it.
All right.
We'll go to P. This looks like it's Mr. Kearns.
Let me share with you a little bit of the background. This was an older lady. She is working part-time. She has a disabled husband that she's supporting. and she honestly thought that the record had been expunged, was the reason she didn't.
Well, there's a
didn't
letter
disclose
in
it.
there saying it's been presented in March of '03, and it,
But they never expunged it.
well, they may
just-
have in their court, but they didn't send it to the
Send it on.
FBI.
That's the backstory. Let's
I mean,
move
when
on.
you read the affidavit, it's almost like it was a mistake because of a miscommunication between the husband and wife anyway, from 1967. Okay. All right.
Felony, so we had to bring it.
That's exactly right. Thank you. Okay. File P, Richard Albert Kearns.
Well, I think we're looking at Mr. Kearns here, it was for, theft, petty larceny. 86, but it still was considered theft, so I have to.
Make a motion that we accept Mr. Kern's employee registration.
Okay, we have a motion by Mr. Harvey and a second by Mr. Tucker to grant Mr. Kearns' employee registration application. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
All right, we'll go to Q. That looks like it's Mr. Morrison. You can
Q.
turn to,
Here it
I
is.
want you, before you open this one up, I'd like for you to turn to page 9. Get an idea of what his explanation is concerning.
Then what came up on
That?
same thing? That's what I'm saying.
Yeah.
It's the same thing.
Words to go with it, so I just don't understand, you know.
Chemicals.
It's just Sudafed.
Yeah, but every day.
Bedroom.
Ephedrine.
It's the ingredient they buy to make meth. That's why it's
I don't
controlled.
think the way he explained it, he didn't really have a choice.
Let them look at it.
Well,
We're just about there. Excuse me.
I think I got a lint all over me.
Yeah. That's when Steve said, Cody comes up by me.
Okay.
Yeah, I don't understand that.
That's true.
Well, I don't know.
I'll look it up.
Don't care.
Hard when I read some of these to figure out why you would. Yeah, I wouldn't.
Well, I'm bored.
I'm
My
gonna go
car
sit
is
down
shot, so
somewhere
I'll
where
just have
nobody's
me a
at, you know,
couple
I
of
guess.
shots of
But I
vodka.
don't drink, so.
Drinking.
Oh.
He was charged with drinking?
I thought he
Yeah,
was
public
charged with-
intoxication.
He was charged with public, he was initially charged with DUI, and then they reduced it to public drunk because they found out his car was, inoperable.
Look, it's the same person?
I'm sorry.
We're looking at, MORSON. He was charged by 2 courteous Nashville Metro officers.
Was that what he said?
Yeah, because he,
I was looking at the
Well, we were looking at the drug possession.
possession of precursor chemicals.
yeah, yeah.
Oh, I didn't see the.
Yeah,
Every day.
just about every 2 or 3 days, yeah.
So what do you guys think?
Make a motion.
Crack either, so.
Well, this ain't got, this doesn't have
It's
anything
a
to do with.
precursor
crack.
for
This
meth.
is a
That's one
precursor
that's
to
when you build houses to the
methamphetamine.
road.
This is one of the main ingredients.
Ketamine, which is
Meth.
Is a
It's
control.
I'm sorry, math. I'm sorry.
methamphetamine use.
The ephedrine, the pseudoephedrine.
Not real fond of him.
Madam Chairman, I make a motion, we deny this application.
We have a motion to deny this application. Do we have a second?
Second.
We have a motion and a second to deny this, Mr. Kern's application. All in favor, voice by saying aye.
Aye.
All opposed? It's denied.
I think you said
Based
Mr.
on-
Kern, but I think we're doing Mr.
Morrison.
I made a mistake.
Morrison.
It's Mr. Morrison.
Thank you.
Is this,
Thank you.
based on
Christopher
poor
Morrison.
moral character?
That is correct.
Yes.
You need to include that in the
Okay.
motion.
Okay.
Based on poor moral
Show
character.
evidence of
That's
poor
correct.
moral character, which is 304.
That would be correct.
Just for the record, I think it's 6232 303, and in this case, it would be B, I, and then subsection A. And B.
Okay, they've already voted.
Okay.
Are we ready to move
Sorry.
on to the next one? Okay, let's do R. Risha, Richard.
Richard Anthony Risha.
This one here, as another was a reapply. This was so current, 2007, public intoxication possession.
Did his probation in '09. He couldn't have been charged in 13. I think he put the wrong year.
So you think the date of arrest is possibly wrong on his application, is that correct?
The date of arrest was in '07.
Yeah, if you look at the
He
sheets
just put the
behind,
wrong
yeah,
year, because he
put the-
completed probation in '09.
Okay.
And then another conviction.
That was,
Cigarette pack. That's interesting.
Or your own story.
He he's smoking poison ivy.
It wasn't his. It was the truck.
I think this Mr. Marshall's missing some numbers on his letter. He's missing some DQA and some company numbers.
EQA number doesn't have to be on there,
It
but the
does
company
not.
does.
Well, the company's missing then.
Seven is the last, was when all these charges were, not 13.
Okay, and this will be Richard Anthony Risha.
Y'all like Mr. Risha?
I don't know what simple possession is.
He had a little bit of leafy green substance in that cigarette pack, which was caused him to be
Cigarette
charged
pack.
with possession of marijuana is what it was. Yeah.
I thought
For
the
us,
cigarette
it's on
pack was
here.
dismissed.
It's all those three
It's
charges.
not.
were
It says supervised probation and drug screens.
Yeah.
1
He
year,
was-
that's why he's
Possession
on
of
the
marijuana.
agenda.
That's for his position.
Yeah.
Yeah, he was charged with simple possession for that cigarette pack he was charged
It
with.
says it was found on the ground beside subject was a cigarette pack and a small bag of green leafy substances.
But he didn't tell us about the green leafy substance, is what we're kind of joking about. It was just the cigarette pack that he owned up to in his statement of explanation.
On his state,
Possession of marijuana, supervised probation and drug screens for 1 year.
I thought on his statement it said it was dismissed. That's why I was confused.
That's why he's on the agenda.
Oh, well, I
Well,
thought
he
he
didn't-
wrote,
Maybe he thinks it was dismissed.
or he wanted it to be dismissed and it wasn't.
That's the more likely explanation.
Or maybe he thought after it was over with, it was expunged or something was,
Held in court.
that's correct. Okay, do we have a motion on Mr. Risha?
I'd make a motion to grant Mr. Risha his employee registration.
Okay, we have a motion by Mr. Harvey to grant Mr. Risha his employee registration application. Do we have a second?
Second.
We have a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? This application is approved.
All right, let's go down here to the very last one, and it's gonna be Exhibit S. Sartain.
Mr. Sartain.
Kevin actually tells you he's the same thing. What is it?
Spelling is atrocious. The one guy spells sobriety S-U-B-R-I-T-I. Reckless, he's W-R-E-C-K. Reckless.
What year was it? 05.
Smacked my wife during a fight.
It was my wife. Yeah, they had some real.
You know, it's like that guy said a while ago, by the time he was paying all of his court fees, that they were even greater than the fines.
County drug fines, 250, drug control treatment, 70. They got a little bit of everything.
Like they charged him for everything but the air he breathed when he was in.
For the air he used while he was in custody.
Yeah.
Pretty old stuff.
Mm-hmm.
That we grant Mr. Sartain his employee registration.
I'll second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to grant Mr. Sartain his application for employee registration. All in favor, voice by saying aye. Aye. All opposed, motion carries.
So we approved him, all right.
Yes, ma'am.
That's all-
Education, we'll get, well, I'll give, she needs time to get caught up on her paperwork, don't you?
You ready for the education review?
Yeah.
Well, we're ready.
We're ready too.
Good. Did anybody look at that course I sent y'all about a month ago and resent the other day? It was 3 nurse call system courses. All of you. I didn't want to make it.
Resent.
They were in some of those
I emailed them again
attachments.
about 2 days ago. They were in this big fat zip file. You had to open.
2 days ago.
All right.
I didn't see him.
They're nurse call trainings. This one's 40 hours. Y'all want to take a minute to review and?
Yes, give the men's.
All right. They're all training on nurse call systems. One's only 4 hours.
You push it off here.
Yours, I think, is. Well, again, if they don't, if it's not handled through the
What are they making out?
Commission on Aging.
What, continuing education?
Oh, they applied for all the above, but I don't think they're good for anything but continuing ed, in my mind. But the nurse call system, if they're not vetted by the, Commission on Aging, or whatever they've renamed that, they have to have a license in Tennessee to sell them. Help I've fallen and I can't get up, but they have to be approved by the, it's not Medicaid or the Commission on Aging anymore. It's through another agency, but they have to, the way you guys worded that rule and the exception, they have to be considered a hospital affiliate to be exempt. I mean, some of these are, the one of them, the first course is a 16-hour course. The second one, which is the Tech Care 400, is a 24-hour course. And the Tech Care 500 is a 4-hour course. I don't believe any of them are acceptable for anything but continuing ed, but I had trouble opening the zip file, which may be why y'all didn't
That was it.
Give these guys an out every day.
Let's try.
I don't remember.
How did you know?
Well, because once I went back to look at it again the other day, I'm like, God, how do you get into this? And then I finally got into it, so I could print all that out.
So you want 4 hours for this?
I mean, and all they are is training on the nurse call systems that they manufacture.
This is all about their stuff too.
Even if you only gave it minimal.
I could get this 4 hours, but no more.
24-hour one for the Tech Care 400.
I've got the,
You've got the 4-hour
I got
one.
the 300. I got the
No, you've got the 500.
the 500, right.
Or you'd have 30 or 40 pages,
Yeah,
Steve.
Ken got to read over that one for the next hour.
At the 300,
You got the one they don't have.
16 hours.
yeah.
400 all through the inside of this thing.
Keith's got 4. Ken, you've got 3.
I
And
got 5.
Steve has 5.
I'll approve 500 for 4 hours. Extended, you know, it would be educational, but yeah, that's it. Yeah.
Well, how you get 24 hours of CEUs out of that?
4.
You've only got a
Got a
4. They've
different
got a
course.
16
You've
and a
got different
24-hour
courses.
one. There's 3 different courses,
Right.
Steve.
There. I think theirs takes about.
Keith has got the
8 hours.
24, and I think Mackenzie's got Ken's got the 300,
Right.
got the 500.
I got the 4 hour.
So you're okay with your
Yeah.
course
You could do 4 hours.
doing 4 hours? But what would be your recommendation?
That's a 3-day course at 4 hour.
Maybe, I'm not that up on nurse call training.
Is it applicable for continuing education?
Yes.
I mean, you could do what you've done in the past, and because it's really not completely applicable, you could reduce the number of hours you're gonna accept it for.
It's a lot of class work. Doesn't that mean you'll be
I could see that one for 4 hours.
right? That may
I
be.
think maybe the other 2 for 16 hours.
Because really,
For 2
the,
years.
Reduce them down to 16?
Each.
And except for the 500 that
Just 4.
Steve's got, we'll make it for the 4 hours they ask.
Do we need a motion or just make a
Motion for all, if you're gonna put it all in one motion.
spirit movie?
Madam Chairman, I make a motion that we grant for continuing education purposes only the Tectone Sound and Signal Manufacturing courses, the course for the 302 system nurse call for 16 hours, the course for the 400 series nurse call for 16 hours, and the course for the 500 system for 4 hours.
Okay. We have a motion by Mr. Roberts to approve these submitted courses, but course number 500 from Tectone for 4 hours, course 400 for 16 hours, and course 300 2 for 16 hours. Do we have a second? We have a second from Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
And one more. Next Friday, Cody and I, or me and one other staff member, somebody is going to make a 2-hour presentation to the Tennessee Electronic Security Association.
Well, I can tell you it's gonna be Bess Bell and Pat Gillespie.
So, anyway,
I'm not gonna be able to get out of the office
so
without a manager.
what I'm planning to do is give a test on the laws and rules.
Oh,
Since-
cool.
I won't give the answers, but I think what we're planning to do is I'm going to go over some of the 09 rules, but really, I'm just going to give the test on the laws and rules, put one question at a time up on the PowerPoint, give everybody an answer sheet, and then after they finish taking the test, then we're all going to grade our papers and see how we did. I believe that's considerable continuing ed for a qualifying agent. What do you think? Anyway, y'all need to approve it so we can give it a course number so that I didn't put anything together in writing.
I think she asked us what we thought, and then she said, y'all need to approve it.
Well, I mean, what I'm saying is,
Well, if it's
need,
okay with us, we have to have a motion to,
Right, I understand,
yeah, okay.
and any of y'all that are going to be there are welcome to participate. You can take the test.
Are you going to do anything beside the test?
I'm going to give them very similar to the presentation that Cody did. It's just that instead of just going over the rules, I was going to give them the test and then also give them an overview of the website and show them how to sign up for Notify. I mean, it'll be a full 2 hours.
Okay, are you going to give them kind of an oversight, an overview of the rules that are proposed
I
and in
can't.
process?
They haven't been
No, they
filed.
haven't been, we can't do that yet.
If they had
You
been,
can't do that?
Not do that.
no, I would like to.
That would be something to be
If
useful
I get
to 'em.
permission, I can put the ethics rules up there and say, this is what the board has proposed, but we haven't had the hearing yet, but I have to get permission
Well,
first.
why not do them all? I mean,
I think that would be very helpful to the industry. And you can put the caveat in there that these are in the process of being approved, because the public will have a comment period on that.
Well, but the problem is doing that, Ken, is that if I get up there talking about these proposed rules, I can't answer any questions about them, because they haven't been filed with the Secretary of State's office yet. They're not public record.
Oh, well, they're
Problem we had
public
this
record
morning.
They're
because
public record
we've
because the
approved them
board
here.
has approved them. But
they-
the department might have a different, I will try to get approval to
See
do
if-
that, because
see
I
if you
think it
can
would be
do that.
helpful.
Here,
They're on Sam Payne's desk, I'm told, and they're making their way through the process, because I spoke, on that other issue that we had earlier about sending the code of conduct out.
He
I
wasn't in
don't,
favor of that either, was he?
well, that's something that's being,
Oh, reviewed.
it's
See,
being
I mean,
reviewed right
we've
now,
always
so I
been
don't
told,
know if it's
especially
too
when you come
soon
to
to be, putting them out there. That's just
Well,
my 2
could
cents.
you, instead of, if there's a conflict or a possible that it shouldn't be done, could you just reference that and tell them to, start,
Be looking.
stay tuned, it's coming?
Yeah, I can do that, and that way, if they sign up for Notify, they'll get a notice.
Yes, soon.
I think
And I
that
can
That's the
say,
biggest thing.
but we've always been told, until you actually have the public rulemaking hearing, you really can't.
This
You
Not-
can
not
send
to
them
give
out,
them-
but you can take written public comments for the hearing, but it all has to be handled through the Administrative Procedures Act, and
well, see what you can do. If you can do it, it'd be good, because it would help the industry to better understand the things that are happening. If you
I think
can't,
one
then you
thing-
can't.
Excuse me, go ahead. I'm sorry, I interrupted, I'm sorry.
Yeah, if you can do it, let's do it. If you can't, then you can't. Simple as that, I guess.
I think from the complaints that you received today, perhaps I need to go over when you turn in a termination notice, when you turn in a transfer
point.
notice, and what does the application mean when we say registered position?
That's a good point. That's
Little
something
things
we're
like
seeing.
that
We're seeing
every
as a
day.
frequent violation. Let's let the industry know this is some things that we're seeing, and you want to be aware of this.
I mean, I could
But
take
there are
copies of the
QAs.
disciplinary report for the last few months, if I could take the
this is-
names off of it. and just say, this is what these fines
Why
have
would you
been
need to
for.
take the name? It's on the internet.
Yeah,
It's
the
on
report's
public
out
record.
there.
Well, I know, but I don't want to stand there and point fingers at everybody in the audience, because a lot of them will be
You-
there.
you-
I
you.
can, but I'm not gonna.
You don't have to do that. If you put it up on a screen.
Just put it on the screen.
Actually, I'm gonna teach all them how to get to it, and maybe what I'll do is pick up the July one and put it on the screen and say, this is the disciplinary report for July, and you can see what the fines have been about.
That's good.
And
We've
it's got
been so
names.
busy
Because,
kind of
you
putting
know-
this together, I haven't spent a whole lot of time on it.
The more information we can give to representatives of the industry, the better it's gonna be for everybody. I mean, really.
Anyway, if y'all would somehow approve that so we can offer a 2-hour continuing ed program and staff, somebody.
I don't know how you're gonna give it a number, but if you want to give it a number following the previous number that we approved, that would be fine.
Well, that's how I assign the numbers,
Okay.
is I use the year, the month, and the number the course was on the agenda.
I'll make a motion then that the staff presentation to the TNESA be approved for, what is it, 2 hours? 2 hours of continuing education.
Second.
We have a motion and a second to approve the 2 hours of training for the, what did you say, TN?
TNESA, it's the
ESA.
Tennessee Electronic Security Association.
Be approved. We have a motion by Mr. Roberts, a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
Motion carries.
Yeah, it's the annual meeting.
I just couldn't remember, I drew a blank on TN,
ESA.
I always wanted to say TENAS, and I thought, not right.
I'll bring
so
it up.
that's why I got you to repeat.
I'm kidding.
Okay, so does that complete the education?
Yes.
Complete the education.
Okay.
I have a question, but I don't know.
You have to ask him.
Board appointments, we've got a vacancy on the board. And the alarm law has a provision that if there's not an appointment made within 90 days, the board can ask for a list from the Tennessee Burglar and Fire Alarm Association and can make an
Now the
appointment.
TNESA.
Well, no, in the law, it's very clear.
I know.
However, we've never done that I'm aware of, and
I do know that Mr. Tucker's application is still the governor's office.
Ken was appointed a year early, so his term expires a year earlier than it's supposed to. I didn't know if y'all would want to recommend that we ask them for a list since the governor hadn't made an appointment.
Cody, where'd you say his application is?
It has to be the governor. The governor makes the appointments.
We don't know where it is in the pipeline, correct?
Where I
But it's
voted.
been there
to the
for,
governor's office.
I
it's
voted.
been there
So
since he
it's in the
submitted it
governor's
in
office.
2012.
Administration's told me I've got vacancies on both programs.
I
They
vote.
told
I
me
voted
their
for him, so
process,
I'm
whatever
planning
process
on
means.
coming.
I guess the question is, because the board is empowered, if the governor hasn't made an appointment within 90 days, do you want to request such a list? I think you would have to authorize somebody to do that. Or do you want to wait and see if,
Let's wait. I make a suggestion, we wait till November, and if we haven't had any action in the next 60 days, then we take a different action. But, give the governor, maybe by some chance somebody would listen to this or get the word that this was discussed, and maybe it would prompt them to get some of these appointments signed off on. But give it 60 days to let them have an opportunity to reappoint Mr. Tucker. We need a motion
I
on
think
that, or
it's
is
a
that
very
just?
reasonable response.
Okay.
no, I just,
But just remember, if there's no action, we'll bring it up on the November agenda then.
Over there meeting with him, Mr. Kilgore. I'm joking with him.
his term expires this December. He's already applied to be reappointed. I've turned in his notice of vacancy.
We gotta get him okayed and redone
That's what I'm saying.
quick.
They tell me it's in the process. They're looking at all programs that have open appointments. Or
I don't think that, again, if we wait till November, that's a reasonable thing.
You know what? I am so hungry, I don't wanna bring it up. we were stuck at the last time that we finished the exams. We had something that we said we are going to bring up at the next board meeting. I'm starving though, but you and I sat here and Keith, and we were all going back and forth, and then we finally said, hey, let's bring it up at the next meeting. Remember, it was something we sat here, all of us did. Can you remember that? He said we couldn't talk about it, I think.
At that time,
It
but
was.
I don't remember what it was.
It was something about some rules that we had to get done. And
Probably these rules.
Can you all remember? We sat here and they said, "No, we're not gonna bring it up. We can't do it in this form."
What wasn't on the agenda?
Right? It wasn't on the
Something
agenda.
like
Oh, it was at this meeting. It was
It was at the last meeting.
the
the
August
testing.
meeting after the test. It was
Right.
the exam specs.
Yeah, we already.
And
I
you
think
guys
that we already
delegated
did
that to
that.
me,
Oh,
so
right,
got
right.
that
Okay,
delegated.
okay.
That's what it was, yeah.
All right, man. My dementia's.
We've
I don't have any updates to give you today because they haven't sent me back the specs, but as soon as they do, I'll send them out for y'all to look at.
December of next year. 14 is you.
Had a great time.
Okay, so does that take care of our unfinished business, everybody?
That's it.
Okay.
New business?
What about new business? No new business? This meeting is adjourned until November the 13th, I believe it is.
But I'm
Thanks,
throwing all this stuff away
everybody.
too. So.
And I can't go get my